To indicate your presence. Mr. Schiebel, please call the names of those who are absent.
Representatives Bacon, Byrd, Bockenfeld, Basenecker, Catlin, Epps,
Here.
Evans, Froelich,
Here.
Gonzalez Gutierrez, Hartsook, Holtorf, Joseph. Luck. Lynch. Morrow.
Here.
Ortiz. Puglisi. Snyder. Story. Taggart. Titone. Valdez. Velasco. Weinberg. Winter. And Madam Speaker,
Representative Judah.
Thank you, Mr. Speaker Pro Tem. I move that the call be raised.
The motion before us is whether the call of the House be lifted. All those in favor say aye. All opposed, no. The ayes have it, and the call is raised. Majority Leader Duran.
Mr. Speaker Pro Tem, I move to proceed out of order for third reading of bills.
Seeing no objection, the House will proceed out of order to third reading of bills. Mr. Schiebel, please read the title of House Bill 1264.
House Bill 1264 by Representatives McCormick and Catlin, also Senators Pelton, R., and Marchman, concerning the authority of the Commissioner of Agriculture to act in instances involving the health of livestock.
Majority Leader Duran.
Mr. Speaker Pro Tem, I move House Bill 1264 on third reading, final passage.
The question before us is the adoption of House Bill 1264 on third reading and final passage. It would appear there is discussion. Representative Bottoms. I really don't have a preference. Representative Holtorf.
Thank you, Mr. Speaker Pro Tem. I want to come forward to the chamber and explain some very important elements of this bill and also talk about an amendment that was brought forth by the Department of Agriculture that really helped make this go to a place that I can certainly support. But I just want to express the concern with respect to House Bill 1264, the original introduced version of the bill with respect to these diseases and these pandemics in livestock, specifically from the avian bird flu and the response to avian bird flu in this case, that really drove this piece of legislation. The contentious issue had to do with who had the authority in this case. And as the bill was written, the authority was given just to the commissioner, which is one appointed executive. Now, in Ag Committee, we had a concern about that because there is a board, there's an agricultural board that are appointed that represent all the different sectors of agriculture, and we were pretty adamant, and the folks that were concerned about just one person having this authority, we were adamant that that referred back to the committee, those that are appointed by the governor, that the commissioner looks to for advisement on all things agriculture. In rural Colorado and in agriculture, I will tell you that that appointment to the Colorado Department of Agriculture is not only highly sought after, but it's very highly respected. And people need to understand the importance of that because those individuals that are appointed to this, and I have a really good friend of mine and colleague and constituent who I've known my entire life, who is now sitting on this board. And he's in cattle production, he's in corn production. And he's been in sugar beet production. He's in seed production for corn seed production, which is a specialty sector of agriculture, where you raise the seed that is sold to producers to be planted. And their family has been in agriculture for generations. He sits on this board, and his opinion and his word matters. And we wanted to make sure that all those board members, in plurality, were still part of the decision-making process. And so an amendment did go forth. And I'm really happy about that amendment that said that, yes, you have to talk to the commission. And the commissioner, one single person, doesn't unilaterally make that decision. It was supported by both bill sponsors, as I understand, the change, rather, in the House, and the department negotiated in good faith to make that change. Now, why does this matter, Speaker Pro Tem? Here's why this matters to rural Colorado. No one person in this great state should have too much authority. No one person in this great state should be making unilateral decisions that affect an entire industry or entire sector. In this case, the second largest industry in the state. That is why the amendment was so important. And it was added to the bill, and I think it makes this go to a much better place. And that's why I'm going to be in full support of this bill. And there will be instances in the future where we have to deal with this. And I believe with this legislation now, the response time will be a little better. Now, there are concerns from another member of the Ag Committee. My colleague that sits beside me did have a very important concern with respect to a judicial aspect of this. And I can't talk to that. I didn't go to law school, but she did. And she's going to also talk to that, because I think it's important that we talk about that as well. But I am in support of this, Speaker Pro Tem, and I want everybody in this chamber to get behind this bill as we move forward. Thank you.
Representative DeGraff.
Thank you, Madam Speaker. All right, so similar to yesterday, I still have some concerns. Some concerns about this bill, largely because I think it is still heavy on the executive side, and maybe the sponsor can address this a little bit more. But when it's talking about disease detection and prevention, where there is a potential for spread of disease of livestock may have been exposed or suffering an infectious or contagious disease, it's the commissioner. So the governor via the commissioner, whenever it becomes known to the governor via the commissioner that the infectious disease or contagious disease exists, they may inspect all livestock. Whenever it becomes known to the commissioner, whenever the livestock are tested, the livestock shall be individually identified and specified to the commissioner, to the commissioner, to the commissioner. The commissioner is authorized to...
Representative DeGraff,
Yes,
is there a
ma'am.
question here?
Ma'am, I'm just going through my concerns that everything, I'll go back, and I was just trying to skip through, but I'll go back through and I'll make it a little bit more clear. My apologies. Whenever it becomes known to the commissioner that an infectious or contagious disease exists among the livestock, the commissioner may inspect all the livestock. When it becomes known to the commissioner that the infectious disease or contagious disease exists among the livestock of the state, the commissioner may compel the testing of all the livestock. Whenever any livestock are tested, the livestock shall be individually identified as specified by the commissioner. So again, the executive branch, this is going under a singular person under the executive branch, and perhaps I'm mistaken in that, but that's what the discussion is for. The official, because like my colleague said, we don't ever want to have too much power in one individual person, and so far I'm seeing one individual person. Investigations access administrative subpoena. The commissioner may investigate as necessary to ensure compliance with Article 50. At any reasonable time during regular business hours, upon consent or upon obtaining an administrative search warrant, the commissioner shall have access to all building, yards, pens, pastures, and other areas in which the animals are kept. The Commissioner is authorized to take administrative oaths and statements, issue administrative subpoenas requiring attendance of witnesses and the production of all books.
Representative DeGraff, are you reading the bill?
I'm reading the parts that I was concerned with about the Commissioner.
Please direct your questions then to the bill sponsors or the body. We don't need to have the bill read again. Thank you.
I was emphasizing these are my concerns of the bill, so I'm leading up to a question, I suppose,
Thank you.
but I'm just highlighting the fact that so far we are at, I didn't take a count or anything, but my colleague pointed out that, whom I have great respect for because of his long experience and his friend's experience, but so far, all I'm seeing is Commissioner. The Commissioner may petition the district court to compel, and upon proper showing, the court may enter an order compelling the witness to appear and testify. So the Commissioner has this legal authority. So the governor, via the Commissioner, I think that's a more accurate way to say it, has the ability to compel the witness to appear and to testify and to produce any documentary evidence. Complaints of record, and then skipping over, then the complaints of record made to the Commissioner. So if we have a complaint made to the Commissioner, and the results of the Commissioner's investigations may, in the discretion of the Commissioner, be closed to the public inspection during the investigatory period, except as provided by court order. So now we have the Commissioner that has, to me, it looks as if the Commissioner has, it looks as if the executive branch, if the governor via the Commissioner has a lot of authority in addition to coming down here to effectively a law enforcement authority, compelling the witnesses to appear, compelling the witnesses to testify, and compelling the witnesses to provide documentary evidence. And these complaints of record made to the Commissioner and the results, and those results and the investigatory results by the Commissioner, now the Commissioner gets to keep them secret unless it is compelled by a court order. So the entirety of this, going back to page 1, because I'm not just reading through it, is concerning the authority of the Commissioner of Agriculture to act in instances involving the health of livestock. So presumably this is an emergent situation, and now we have the Commissioner that has all these, not the Commission, but the Commissioner has all of these individual powers that have been given to it. And then the Commissioner, save a court order, and we have no idea how long a court order would take, would be able to keep all investigations at the discretion of the Commissioner to be closed to public inspection during the investigatory period. So during the investigation, so to me, let's see, where does the Commission come in? So now we're talking about quarantine, still under the Commission. Once testing has been confirmed of presence of infectious or contagious disease, the Commissioner may quarantine any specified livestock premises, county, or district in preventing the spread. And then we're going to amend as follows: the condemnation. So, all right. So this is where the amendment was made because it's highlighted in gray. Whenever the State Agricultural Commission finds it necessary to condemn and destroy any animals or property within the state because of the contagious or infectious disease, the animals or property shall not be destroyed until after an independent appraiser appointed by who? By the governor via the Commissioner will appoint the singular appraiser. And what was taken out of that? 3 appraisers, 1 of which would be by the owner, 1.5 of which would have been by the owner. So in this case, there would have been a little modicum of 5th and 14th Amendment protection where you're not going to be deprived of life, liberty, or property. And again, 5th and 14th Amendment, because somebody thought those were important, that somebody other than the commissioner deciding whenever the disease exists, whenever what investigation should ensue, what buildings should be investigated, to administer oaths, take statements, compel witness statements, testify, and produce documentary evidence, all to the commissioner. And the one bit that was back here that would have protected some level of 5th and 14th Amendment gave somebody, the cattle or the rancher or the farmer, some modicum of protection of 5th and 14th Amendment was that one and part of another appraiser would have been appointed by the person in question. But now that entire power to tell the individual how much their potentially entire herd was worth now rests in the hand of one person. This doesn't even say the commission will make that determination. It says whenever the State Agricultural Commission finds it necessary to condemn and destroy any animals or property, then the commissioner then the governor via the commissioner, or the governor via the singular point of failure in this case, the governor appointed effectively appraiser, now has all the authority to determine what that herd is worth. Now, do we have any anticipation?
Representative DeGraff, you have 1 minute remaining.
Thank you, Madam Chair. Speaker, my apologies. The appraiser shall make the report to the commissioner under oath as to their appraisal, and the commissioner shall forward the appraisal to the governor with the recommendation that the appraisal shall be considered a just bill against the state of Colorado. So the commissioner has perhaps has too much motivation to lowball that for whatever reason. So I disagree with my colleague. I think there's far, far, far too much power presented here. This is a further centralizing of government, further centralizing of control that never works. Thank you.
Representative Luck.
Thank you, Madam Speaker. So I was referenced in a prior presentation, and so I have been encouraged to share some thoughts as to why I voted no on this bill in committee. So just by way of procedural history, this bill was introduced into the legislative process on March 27th, which was a Monday. It was heard in the department, or in the Ag Committee that following Thursday. In talking with stakeholders about it, they had been flagged of the information on Wednesday. And because of the need to get back on the floor, our committee testimony and time for discussion was limited to approximately an hour. As a result, the ability to ask questions of necessary folks was limited also to the point where representatives were encouraged to ask just one question and share 5 minutes of closing time amongst themselves. As a result, I had a number of questions that remained unanswered. And unfortunately, I was unable to get those questions answered in the time from that committee hearing until we discussed this on seconds. And so I put forth a variety of those questions at this podium, and the bill sponsor was kind enough to say, let's look at this and let's work through these things, not today, because we don't have the time, but let's do it as it goes over to the Senate. Let's flesh these things out and make sure that they are attended to. So I stand up here again with those same questions, many of which have been identified by the prior speaker as to the consolidation of power into one branch, the further eroding of the power of this particular branch. I don't know why the legislature continues to to do that, and also why the legislature continues to erode the power of the judicial branch and just consolidate everything into one group. I suspect that if the governor, there's a reason why we divide power. And this bill continues to consolidate it without giving recourse for folks to adjudicate their rights in an effective way. So I'll focus in on a section I didn't focus in on during seconds because I assume that everyone was listening on seconds to the other points that I made. But the question of the condemnation of livestock and the independent appraiser. Now, I've spoken to the bill sponsor about why move it from 3 appraisers, 1 appointed by the commission, 1 appointed by the property owner, and 1 appointed by those 2 individuals, so as to have a mediation-like style where all of those interests are balanced and appropriately honored, and move it into 1 independent appraiser. Why do that? Well, and I understand that the idea is we want to get these appraisals done as quickly as possible so that these individuals can get reimbursed as quickly as possible.
Excuse me, Representative Luck. Members, we are on 3rd reading. Ask you not to have conversations. Thank you. Please proceed.
Thank you, Madam Speaker. So why would you do that? Okay, makes sense. Makes sense that you would want to speed up that process. But there is no recourse provided. So if that farmer, if that rancher or rancher disputes that appraisal, they have nowhere to go. You know, it's unfortunate. It's unfortunate that the desire to vet these things because they impact people is seen so poorly because it's seen as filibustering and wasting time. That's really unfortunate because some of us genuinely are trying to make sure that the policies that leave this building and that impact other people will impact them in the best way. Do you want to have a situation where your property can be condemned and the value of that property determined by 1 individual? And if you have a question as to that determination, to not have any opportunity to challenge it? This is a serious issue, and one that we should have flushed out in this body. Instead, it seems that we enjoy rubber stamping things. Rubber stamp, you're the one. You make bill time oh so fun. Rubber stamp, they're totally fond of
Representative
you.
Luck.
Thank you.
Representative Bottoms.
Thank you, Madam Speaker. As my previous 2 colleagues have stated, I'm also worried. I think the concept behind the bill with the trying to protect the livestock and doing these things, I think that's a good idea. The problem is the consolidation of powers. The amendment does address that some, but there still is a consolidation of powers here that starts with the governor's desk and then goes to the commissioner. And that's an unhealthy thing in any part of this, in any industry, in any setting. And I think in the agricultural setting, I think this is going to be huge. I think it could. It may not be any problems with this, but I think it could be huge when it comes with consolidation of power, that it hinders this entire industry. Because one person can begin with the commission, but not. It still comes back to the commissioner, but can affect the entire agricultural industry, and I just think that's a bad idea. I think we've got to keep any attempt to consolidate should be resisted from us at all times in any setting in any industry, and so So, yeah, I'm against this bill.
Seeing no further discussion, the question before us is the passage of House Bill 1264 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representatives Armagost and Winter, please close the machine. With 54 aye, 10 no, and 1 excused, House Bill 1264 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1153.
House Bill 1153 by Representatives Armagost and Amable, also Senators Pelton, B., and Rodriguez, concerning a feasibility study to determine pathways to behavioral health care for people with serious mental illness and in connection therewith, making an appropriation.
Madam Majority Leader.
Madam Speaker, I move House Bill 1153 on third reading, final passage.
The motion before us is the adoption of House Bill 1153 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Holtorf and Winter, please close the machine. With 59 aye, 5 no, and 1 excused, House Bill 1153 is adopted. Co-sponsors. Representative Froelich, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1227.
House Bill 1227 by Representatives Judah and Ortiz, also Senator Will, concerning the enforcement of requirements imposed on pharmacy benefit managers and in connection therewith, making an appropriation.
Madam Majority Leader.
Madam Speaker, I move House Bill 1227 on third reading, final passage.
Seeing no further discussion, Mr. Shebel, the question before us is the adoption of House Bill 1227 on third reading, final passage. Mr. Shebel, now please open the machine. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representatives Bockenfeld and DeGraff, please close the machine. With 55 aye, 9 no, and 1 excused, House Bill 1227 is adopted. Co-sponsors. Representative Epps and Vigil co-sponsor. Please close the machine. Mr. Shebel, please read the title to House Bill 1105.
House Bill 1105 by Representatives Parenti and Titone, also Senator Cutter, concerning the creation of task force to examine issues affecting certain homeowners' rights and in connection therewith, creating the HOA Homeowners' Rights Task Force and the Metropolitan District Homeowners' Rights Task Force, and making an appropriation.
Madam Majority Leader.
Madam Speaker, I move House Bill 1105 on third reading and final passage.
The motion before us is the adoption of House Bill 1105 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Bockenfeld. Please close the machine. With 45 aye, 19 no, and 1 excused, House Bill 1105 is adopted. Co-sponsors. Representative Vigil, co-sponsors. Representative Froelich, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1120.
House Bill 1120 by Representatives Joseph and Ortiz, also Senators Fields and Winter F., concerning eviction protections for residential tenants who receive public assistance and in connection therewith, making an appropriation.
Madam Majority Leader.
Madam Speaker, I move House Bill 1120 on third reading, final passage.
The motion before us is the adoption of House Bill 1120 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Evans? Please close the machine. With 44 aye, 20 no, and 1 excused, House Bill 1120 is adopted. Co-sponsors. Representative Epps, co-sponsors. Please close the machine. Mr. Shebel, please read the titled House Bill 1178.
House Bill 1178 by Representative Froelich, also Senator Winter F., concerning enhancing court personnel's recognition of domestic violence to access federal funding and in connection therewith, including the recognition of child abuse.
Madam Majority Leader.
Madam Speaker, I move House Bill 1178 on third reading and final passage.
Representative Bradley.
Thank you, Madam Speaker. Again, I understand where the bill's coming from. It's a very personal thing for me, having lived it. I have a hard time believing that a one-size-fits-all approach happens to be the answer for everyone. Public health, I told you guys that I listened to fraudulent claim after fraudulent claim being brought forth, and we sit on public health to listen to this witness testimony and listen to what has happened to these people because of fraudulent claims of child abuse and sexual assault and kids being ripped away from their parents who were innocent. And the bill sponsor yesterday said it's a very slim chance, so I just wanted to read this article of a Moffat County caseworker accused of fabricating child abuse neglect investigations has been charged with forgery. The discovery of falsified reports alarmed state officials who sent 15 caseworkers to Craig in 2020 to reinvestigate 80 abuse and neglect cases. County caseworker accused of fabricating reports to make it seem as if she checked on children who were the subject of abuse and neglect claims is now facing charges of forgery and abuse of public records. Hester Renee Nelms was under investigation for more than a year by the district attorney's office in Moffat County, where a crew of 15 caseworkers from Across Colorado set up operations in 2020 to reinvestigate more than 80 reports of child abuse and neglect. Numerous families, including some who spoke to the Colorado Sun, said that no caseworker ever came to check on their children, despite detailed reports in the state's child welfare database that those visits had occurred. An arrest warrant in the case, released this week after a request from the Sun, describes how Nelms' notes regarding several children were made up and inaccurate. Investigators discovered that in multiple cases she had never visited homes or interviewed kids and parents, despite writing in detail about the contents of their bedrooms or family members' jobs and medical conditions. Investigators found at least 50 cases, does not sound slim to me, containing falsified details, including many in which Nelms never made contact with the children or parents. They included entries into the state child welfare database about people that did not exist and false documentation regarding the death of parents, false medical issues, fictitious supports, and or employment according to the arrest warrant. In one 2019 case, Nelms wrote about a mother that had cervical cancer and wanted to spend as much time as she could with her 4 children, including a 5-month-old baby. Her report described a house fire the family had endured and said that the mother was in nursing school. Neither detail was true, nor did the mother ever have cancer, investigators found. Also, there was no baby in the family. In another case, Nelms wrote that the mother of the child, who was the subject of a sexual abuse report, worked as a cook and that her daughter had a boyfriend. But in reality, the daughter is gay and the mother worked at an auto lube shop, so completely falsified again. No children were found to have been injured or killed because of the shoddy casework, according to records previously released. State child welfare officials in 2019 notified Moffat's County Child Welfare Division that it was behind on meeting requirements for abuse and neglect assessments, which counties are supposed to complete within 60 days. The county hired a former child protection caseworker to perform an audit, which was found that of the 120 abuse and neglect cases that were open, 90% of them were assigned to this caseworker. Annette Norton, then the head of Moffat County Department of Human Services, allowed Nelms to focus solely on closing the 120 cases. Yet after a month, Nelms had just finished working on just 13 of the open cases, so Norton fired her, according to court documents. The caseworker who took on Nelms' workload soon discovered inaccuracies and complete untruths in the reports. In the first case, the new caseworker looked into, in which a little girl's bedroom decor was described in Nelms' report, the worker, Marky Green, found that Nelms had never actually been to the child's home. The mother looks at Miss Green and asked her what contact and by what caseworker the investigator wrote. The mother explained there was no contact and no interview. The auditor then pulled more of Nelms' case files, choosing at random, and she and Green made similar discoveries. This led to intervention by the State Child Welfare Division, which rounded up 15 caseworkers from various counties to re-examine every case that Nelms worked. The team discovered a pattern of fraudulent paperwork that stretched over 2 years. Nelms did not respond, of course, to a request for interview. She just said that she had been moving further and further behind. The cases were piling up, so she needed to fabricate documentation, but said she relied on her memory when she entered reports into the statewide database and sometimes mixed up families. She was then charged with felony forgery and misdemeanor abuse of public records. The Sun asked the 14th Judicial District Attorney's Office about the status of its investigation into Nelms' caseload 8 times over the past year and a half. The office's spokeswoman, Leslie Hockaday, recently emailed a news release to The Sun dated March 22nd, noting that an arrest warrant had been issued for Nelms on this past November 29th. She's not been taken into custody, and a judge set a $5,000 personal bond for her. All this to say that we should protect children. Children are our greatest asset. I would not want anything to happen to mine, but I can't be remiss in being on public health and listen to fraudulent trails reports and fraudulent child abuse reports and fraudulent sex abuse reports and claims from ex-in-laws that just want to get back at women and ex-boyfriends and ex-husbands that make these women or men victims again. And I just don't agree that we as lawmakers make decisions based on a one-size-fits-all approach. This does not do justice to the people whose lives are ripped apart by fraudulent claims and their children are ripped away from them for sometimes years or forever. And I appreciate you guys listening to me. Thank you.
Representative Evans.
Thank you, Madam Speaker. I truly and genuinely want to like this bill because everything about this bill speaks to what I did for 10 years in law enforcement, which is standing up for those individuals that don't have a voice and empowering those folks who have been put into terrible, powerless situations to get a moment's rest and a moment's breathing room to be able to collect their thoughts and make what is oftentimes one of the hardest decisions that one can make. And that is, first, the acknowledgement of an abusive situation, and then secondly, finding the strength to be able to do something about that situation. It's a story that I've seen over and over and over again, and it's a story about which, I mean, really there's never enough training on these situations and these topics. More training is always appropriate. More training is always better because they are so complex. And there's so many new ways, new research that comes to light that shows and highlights how abusers generate and maintain a power imbalance, how they use that power imbalance to control their victims, and ultimately, how victims suffer in those power imbalances. So in this bill, when I read statements where it talks about the child's safety is the first priority of the courts in any proceeding affecting the child's care and custody, I completely agree with that. That is absolutely what we should be doing. Because that is standing up for the victims, that is standing up for those individuals who are in a powerless situation and who need to be protected while they get back on their feet and reclaim the sense of control and agency that they might have lost. It's a critical task, and I wholeheartedly support it. As I've mentioned, though, in these cases, the devil's in the details, as it always is. And when I stood up here on seconds and I kind of laid out some of the testimony that we heard in committee and some of the arguments on both sides, there were a couple of things that stood out to me. The bill talks about, on page 3, a child's risk of abuse increases after a perpetrator separates from that perpetrator's domestic partner. And then it talks about how empirical research indicates that allegations of abuse are regularly discounted by courts when there's a parental allocation case. So what you have here is an example where there are legitimate cases of abuse, and those legitimate cases of abuse are ignored. Oftentimes what you have happening there is a situation in which the abuser, the person who has been in control, they're calm, they're cool, they're collected, they're put together, they're smooth talking, they know how to control a situation because that's what they've been doing. And so, of course, in a situation like that, you have the abuser who looks completely put together, and you have the victim. They've been victimized. They're not used to being in control. They're desperate. They're like a drowning person. And they present that way in court. And so, of course, to the average observer, someone who's looking at the situation, there is a high propensity for bad decisions to be made. For the abuser, who's calm, cool, collected, and slick talking, to get custody, and the victim to be effectively discriminated against because they're a desperate, drowning person at that point, and they present that way. And I absolutely stand for more training in that regard, but there's another side to that coin. And there's a side to that coin in which allegations are made by that calm, cool, collected individual against their victim, in which the abuser is actually turning the tables against the victim. They're using the fact that they're calm, cool, and collected. And it's not enough that they've been able to get away with abuse for however long they've been committing it. But then they go and they add insult to injury, and they make counter allegations against the victim. And those are cases of illegitimate allegations, but sometimes, because that abuser is calm, cool, collected, and smooth talking, the false, illegitimate allegation moves forward because it was made by the calm, cool, collected abuser, and the correct, truthful allegation, which is often disjointed, emotional, sometimes even hysterical, truthful, that's the allegation that suffers. And so as I read through this bill, I want to make sure that both sides, both types of victims are having a voice. Victims who make an outcry, victims who have been abused, victims who present like a drowning individual, who have a legitimate case. I want to make sure that those legitimate cases are heard. But I also want to make sure that when a well-reasoned, good-sounding, logical, illegitimate report is made against a victim, I want to make sure that the court has the training to screen out those illegitimate cases just as much as they have the ability to move forward on the legitimate cases. Now, I honestly still don't know which way I'm going to vote on this bill, because I stand for so much that this bill talks about. It talks about more training. We desperately need that. It talks about increasing the knowledge base for our courts and for the folks who work in courts and who are intimately involved in these cases, and we desperately need that training. But I'm concerned by some of the language in this legislation that seems a little bit lopsided, that seems like it favors those legitimate cases where a victim is ignored, but maybe a little bit to the detriment of illegitimate cases that move forward. Both are real. Both happen. The tools and the methods that abusers use to generate and maintain a power imbalance, unfortunately, know no bounds. They will use any tool, emotional, physical, psychological. They will use children. They will use pets. I used to tell my animal management officers, you are the first line of defense against domestic violence. Because if somebody is abusing a pet, the statistics show that it's just a short step away for them to start being abusive towards kids and then a domestic partner. That training needs to be out there. But we have to ensure that when we are training and empowering the courts and those individuals who work in the court system to untangle these cases, that they're receiving training on what I would term as broadly both sides of the equation. Legitimate cases of abuse that are ignored because the person who is outcrying is a victim and doesn't present that well. In law enforcement, we said they presented appropriately. We have to make sure that those legitimate cases are not ignored. But we also must ensure that smooth, slick, controlling, well-reasoned counter-allegations of abuse also do not move forward. And as I read through this bill, I just want to make sure that it's balanced and that equal weight and equal credit is given to both sides of this equation, and that the bill and the legislative declaration don't favor one method of abuse over a different method of abuse. So I just want to present those facts, and I just want to put those things out there. Again, I desperately want to like this bill. I think it does so much good.
Representative Evans, you have 1 minute remaining.
Thank you, Madam Speaker. It does so much good. It moves the needle in the right direction. But I want to make sure that in our zeal to do right and to get that additional training, that the training is balanced, that the legislative declaration is balanced, the legislative intent is balanced, and that both types of victims, legitimate victims whose outcries are ignored, and legitimate victims who are the recipient of a slick, well-reasoned counter-allegation that both of those victims get justice. So I just present that information to you. Like I said, I still haven't decided how I'm going to vote on this. I think it's a good bill. I do have some lingering concerns with it. Thank you very much.
Representative Bottoms.
Thank you, Madam Speaker. This is some of what previous representative is saying from a police side. I can attest to from pastor's side, where you interact with these people for years, and then all of a sudden you realize that there has been either abuse that has begun or long-term different kinds of abuse, right? And so I strongly agree with the training concept of this. This has got to happen. To think that this is, they go through a training and now they understand all this, that doesn't happen. Every single one of these moments and cases are going to be unique. I've never come across, in hundreds and hundreds of these, I've never come across a situation that's exactly right, exactly the same. I mean, people lie. Abusers most definitely lie. All of these factors are going to be included in this constantly, and my desire in every single circumstance has always been to help the individuals. But and this is stated in the bill, and this is huge, is always make sure that the kids are being protected through this. I've seen it where the kids are divided, and even the kids will perceive the issues differently. The kids can even lie about this. The kids don't understand the big picture, and they're trying to protect one, trying to protect the other. These things are as messy as you could imagine. So the training has got to happen. If this bill is just about training, I would be 100% for it. But I do think there is a kind of a limitation in the bill that kind of slants toward one direction in this. And that's where it's going to actually be harmful. We've got to have this training. And again, so you put a police officer through this training. That's still such a challenge to go into this and try to figure out who's telling the truth, who's not telling the truth. Again, like I said, I've dealt with this where we've known people for years, and one of the things that I've told my entire staff is there's always two sides to the story, because it's easy when somebody comes in and starts talking, well, they did this or they said this or whatever. Because of your relationship with them, you immediately assume they're telling you the truth. And I've had to go to my staff many times over the years and say there's always two sides to the story. Don't get caught up in a story until everybody's in the same room and everybody's talking together and you're interacting together and you've got other people helping in the process. Because why? People lie. Abusers lie. Everybody will get caught up in this thing, and some people are telling wrong stories without even realizing it. And so I think we've got to be careful with how the whole bill is presenting the issue. I would like to see it limited to just the training, and let's do this as often as possible. A lot of different groups out there, a lot of different police forces have these kind of trainings, and I think they're necessary. I think they need more. You even have it with the things like the DA's office and stuff like that, where they're trying to train them. And so I agree with the training side of this. But I think you got to be careful if you start limiting one group over another group, because that's going to hurt people in the long run. Everybody can be abused, and everybody can be an abuser. And that's where we have to have the understanding and the training to be able to process this and vet this through the process. So I will vote no on this.
Representative Winter.
Thank you, Madam Speaker. When I first got up and talked about this bill, I commend the bill sponsor's effort in trying to bring training, trying to bring clarity, trying to make the system better so they can sniff out and point out some of the bad actors in these situations. But at the end of the day, it's about the kids. And I told you all the story about a friend of mine that I went to college with, and I watched what my colleagues were talking about
it played out in front of my eyes. And it's just so upsetting to me because she was being abused physically, emotionally, mentally. And at the end of the day, they lived in a small town, and we all know how small towns are. They're great in some ways, but there's people with massive influence in small towns. And family feuds in small towns, and it played out into this. It played out into this in the courts. I hate to say it, but it happens. And I watched how her influential ex-husband was able to manipulate the system against her, make claims like my good colleague from Weld County said, made it look like she was crazy, made it look like she was unstable. Well, all along he was the calm, cool, collected, slick, devious character that he's talking about, and it happens, and this is a real concern for us. I agree with the training part of this, but I also saw this happening. I saw him drive a wedge in between her and her kids, and I saw how they acted up against her and her parents and the rest of her family. And to this day, they have a relationship, but it's tainted. It's a tainted relationship. And I think I would be remiss if I didn't come up and tell her story and explain that, because my wife and I were there for her through a lot of this. And to see how things were manipulated against her, and to see how it still affects her and her children's relationships today. So where I do stand in support of the training, helping our courts pick this out, I also worry about the people that fall through the cracks, and I also worry about the cunning, devious people that know how to play the game. And that's a reality when we look at these things. So, like my colleague from Weld County, I'm going to go back and I'm going to let my heart do some talking and see where I'm going to go on this bill. There's some good in this bill, and I think there's some bad in this bill, but at the end of the day, think about that small group of people that could be affected by that. I watched her go through it, and it was hard to see her go through that time. So thank you for listening to me.
Representative Holtorf.
Thank you, Madam Speaker. To the two previous colleagues and my friends, it's not hard for me to decide how I'm going to vote. There's two things that make this easier for me, and I want to explain those so you understand. There's a companion bill attached to this bill, Madam Speaker, and it is to the bill, but I want folks to know, and this isn't by accident, to the bill sponsor who supported this and brought this forth. Okay, 1108. It's a task force that's trying to dial in on how to get to the essence of how we train for victims and survivor awareness. Because I think the training is so important. And then in the courts here, with respect to this bill, that training, this bill's going to support that training. And I believe that training, Madam Speaker, and to my colleagues here, and I want to know why and no deference to my colleagues at all. You need to understand something. If the courts get the right training, maybe there can be a better outcome for the victims. Yeah, there's collateral damage in these domestic violence and domestic abuse cases. There's a lot of collateral damage. But the largest collateral damage is the kid or the children. And if the court doesn't get it right, then that could be the largest part of the collateral damage. If the training helps the court sort out in those specific cases if there is or is not abuse, this actually directs for certain specific requirements. Let's talk about the training that this bill empowers. Let's talk about the 20 hours of training to get it started, and then 15 hours of training every 5 years. I don't even know if that's enough in this regard. I'd say at least 5 hours of training a year, but I'm not asking to amend the bill on thirds, Madam Speaker, but I'm telling you, If we can get more training in the courts, if we can get more protection for the children who may be suffering not only from emotional harm and emotional confusion from the situation that's occurring between parents, but more specifically from physical or sexual abuse. If we can prevent the physical and or sexual abuse in these disputes, then the children win. The children win. I read in parts of this where there are remedies and there are provisions for trying to reunify. I don't think this is trying to exclude parents in these court proceedings in future time from some type of reunification. I don't see that. But when these courts are making these decisions with respect to domestic violence and child abuse in a state court, and we have the mediators and these special masters that are involved in these caseworkers that are involved in these situations, and they've got to talk to the court administrators and they have to present information. And I agree, there's, my previous colleague who I greatly appreciate from Douglas County, there are bad apples in every barrel. There are. There's bad people in the world. And they do horrible things. And if they cut corners, if they cheat, if they try to do end-around run on their work, and then these things slip through the cracks as she presented, yeah, that's terrible. But that doesn't mean that we don't support this training. That doesn't mean we don't try to make the situation better. So, I just want to say, as I'm sitting back there listening, no deference to any of my colleagues, but I know what I'm going to do, Madam Speaker, on this one, and I'm going to try to protect those kids. The parents are going to have to do the best they can. They're the adults in the room, but the kids are the ones that are the true collateral damage. And when those kids get hurt in horrible ways, you can never take that back from them. They got to live with that the rest of their lives. And that is so hard. I don't know from personal experience. I don't have this directly in my family. I do have friends, and I've had people very close to me that have had to live with this. And it's really hard to have a healthy relationship with those people because they're so damaged. They've been so hurt. And they carry that the rest of their lives. So if we can avoid it, if we can do this training, if we can get the courts to make better decisions, Madam Speaker, if we can do something to avoid that, this is something I'm passionate about. If we can do something to make a better outcome, then I think it's pretty easy for me to make a decision today. Thank you, Madam Speaker, and thank you for your time and attention. And with all due respect to my colleagues, I know what I'm doing here.
Assistant Minority Leader Puglisi.
Thank you, Madam Speaker, and I'll be brief. I think this bill is really good because I do think there's more needs for training in the court system, and the ability to leverage federal funding I think is always important to bring more money into our state to help victims. I do want to acknowledge, though, as my colleagues did, and I didn't want to miss this opportunity to say very definitively, there are some huge cracks in our court system that allow abusers to continue to re-victimize their abused. And we need a fundamental change in that system. And I will continuously come up here and show those cracks because when you depend on the court system to protect your children and they turn their back on you, it is incredibly hard. And you have to sacrifice everything to make sure you can get your kids and you can protect them. And the court system is broken, personally, and so do we need more training? Absolutely. Do we need to know how people are being victimized? Absolutely. But I think there's some fundamental cracks in the system that also need to be addressed. This bill isn't the one that does it, but I do appreciate the step towards that, so thank you.
Representative DeGraff.
Thank you, Madam Speaker. Usually in these things, I expect some sort of vulgarism at the end where somebody will say, if you don't believe this, then you're for abuse, and that's not the case. We're dealing with something that is absolutely heinous, the abuse of a child, even a pet, definitely a spouse. Any of the abuse has there's no place for it in society. There's no place, and that is our role of securing the inalienable rights of life, liberty, and the pursuit of happiness for our constituents, smallest to largest, it doesn't matter. I do have some concerns about this bill, and I am disappointed that the discussions on these very serious matters are truncated because we're going for quantity over quality. We need to protect the kids. We need to protect spouses. We need to protect pets. We need to protect everyone. But we're making laws. And we need to make sure it's done correctly. We've corrected, we keep getting bills back where we have to make a repair in what was done last year, what was done 2 years ago. Today I heard one that there were 2 bills passed 2 different years, and now we're going to correct the mistakes that were made in those. So I'd like to just make the plea to slow down on some of these things and really hash these things out. So I do have a big question on what we're doing from the legislative branch reaching into the judicial branch. Because there's been a lot of things that have said here that the court system is broken. And this entire bill basically says the court system is broken. Our judiciary is broken. Now we have means as legislators to deal with a court system that's broken, but we're not going to do that. What we're going to do instead is we're going to try to treat a symptom, and we're going to pave over a symptom. Try to, anyways. The likelihood, low. But what we're doing is we are muddying the water. We have distinct branches. So my question would be, if this is so obvious that we need training, and I'm not disputing that. I'm not disputing the need for the bill. I'm not disputing the need for the protection. I'm questioning the propriety of this body reaching into the judicial branch and saying that we think you need training. We're not going to say what training that you need. We're going to leave that to somebody else. So presumably the judiciary would now decide who does the training, who schedules the training, what is part of the training. We're just writing a check. We're just saying, here's a blank check, you do you. You go do this, our blank check to you, for you, you do whatever you want. I don't see that as proper legislation. Do we need to realign the judicial branch? Is there something wrong with the judicial branch? Well, maybe we should figure out what the problem with the judicial branch is. Because we're definitely saying this bill says there's a problem with the judicial branch. It's just not going to identify what it is. It's not going to say what it is. It's just going to be, we're just going to prescribe to the judicial branch to do something. Well, if the judicial branch is broken, who's going to choose this training? What training are they going to choose? If we're saying the judicial branch is a problem, is it a good thing? Is it a wise thing to say, hey, the people that we're saying are a problem are going to be the ones to solve the problem and then expect not to get a bigger problem because we threw a check at it? It's very dysfunctional. It's like a dysfunctional family here. Just throw money at the kids. Buy favor. Will this fix the court system? No. Is this a heinous problem? Yes. So it's not me that's saying that there's a problem with the court. This bill is saying that there's a problem with the court. And then the House, this body is saying that there's a problem, we're going to give the people who are the problem more money to solve the problem. And to me, that's a problem. So we're actually making laws and I question whether they're going to solve the problem. Not whether there's a need for solving the problem. There's definitely a need for solving the problem. One kid suffering abuse, one spouse suffering abuse, that is way too many. It's far too many. But this, for all the, I won't say good intentions, although I do think it has good intentions, I think it's noble. I think it's going in the right direction, but it's also taking us in the wrong direction by dabbling in places that we're not supposed to, because we look at it and we say, well, we just do. We don't look at the constraints that we've been set under in order to have these differentiated powers in order to not go down the wrong road. So now in this case, we're dabbling in the judiciary. In the previous bill, we're giving essentially unilateral control to the governor over the ranching industry. So we're just going so far outside of our lanes in every way, shape, and form. It's really no surprise that we're confused as to whose role is what, and that we dabble in this. So nobody knows who's in. We're getting into, judicial's getting into our lane, we're getting into judicial's lane, we're giving all the power to centralized government to create the idyllic feudal society. I like the intent of the bill. I'm behind the reasoning of the bill. I just can't get behind the bill. Thank you.
Seeing no further discussion, the question before us is the adoption of House Bill 1178 on third reading and final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
No.
Representative Epps votes no. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representatives Frizzell, Harridan, Sirota. Please close the machine. With 48 ayes, 16 no, and 1 excused, House Bill 1178 is adopted. Co-sponsors. Representative Vigil, co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1237.
House Bill 1237 by Representative Velasco, also Senators Will and Exum, concerning inclusive language access in local emergency situations and in connection therewith, making an appropriation.
Madam Majority Leader.
Madam Speaker, I move House Bill 1237 on third reading and final passage.
The motion before us is the adoption of House Bill 1237 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representatives Bradfield, DeGraff, Frizzell, Hartsook. Please close the machine. With 59 aye, 5 no, and 1 excused, House Bill 1237 is adopted. Co-sponsors. Representative Froelich, Epps, co-sponsor. Please close the machine. Mr. Shebel, please read the title Senate Bill 74.
Senate Bill 74 by Senators Van Winkle and Janal, also Representatives Froelich and Doherty, concerning continuing human trafficking prevention training and in connection therewith implementing recommendations contained in the 2022 Sunset Report by the Department of Regulatory Agencies.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 74 on third reading and final passage.
Representative Frizzell.
Thank you, Madam Speaker. I'd just like to speak to this bill just a moment because it's an important bill. This program was created in 2019, and so far it has trained about 8,000 people on how to identify and offer assistance to those who are being trafficked. Human trafficking is actually a pretty significant issue in my beautiful little town of Castle Rock, simply because of where we're located. Just as we have a great program to retrieve vehicles that have been stolen because people stop in Castle Rock to get gas, we also see a lot of people trafficking other humans, whether it's for sexual trafficking or labor trafficking, coming through Castle Rock, stopping to get gas or grab something to eat. So the purpose of this particular bill is simply to extend this program. It was set to sunset in 2022. And this bill is to extend it until 2030. Again, this program doesn't serve to capture, it serves to inform. And this is kind of a hidden crime, because a lot of times you pull into a gas station and you look over and maybe there's a van putting gas in next to you and you don't know what's going on inside of that vehicle. Or you see somebody get out of the van and perhaps they look disheveled or they have kind of a scared look about them. And if you're somebody who's actually trained, you might be able to understand what's going on and that maybe there's a problem and know how to address it. This is how we stop this really heinous crime. And so I would ask for an aye vote on this bill to get this important information out to more people than 8,000. Because think of what we can do in 7 more years. We can really grow and hopefully tell these people who are trafficking through our state that this is not one that they want to do business in. Thank you for your time.
Seeing no further discussion, the question before us is the adoption of Senate Bill 74 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
No.
Representative Epps votes no. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Please close the machine. With 63 aye, 1 no, and 1 excused, Senate Bill 74 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to Senate Bill 8.
Senate Bill 8 by Senator Moreno, also Representative Lindsay, concerning opportunities for youth involvement in the review of the state's education standards and in connection therewith making an appropriation.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 8 on third reading and final passage.
The motion before us is the adoption of Senate Bill 8 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representatives Catlin, DeGraff, Joseph. Please close the machine. With 45 aye, 19 no, and 1 excuse, Senate Bill 8 is adopted. Co-sponsors. Representatives Froelich and Vigil co-sponsor. Please close the machine. Mr. Shebel, please read the title to Senate Bill 154.
Senate Bill 154 by Senators Sullivan and Hendrickson, also Representatives Parenti and Taggart, concerning the continuation of the Veterans One-Stop Center in Grand Junction and in connection therewith implementing the recommendations in the 2022 Sunset Report by the Department of Regulatory Agencies.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 154 on third reading and final passage.
The motion before us is the adoption of Senate Bill 154 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Please close the machine. With 64 ayes, 0 no, and 1 excuse, Senate Bill 154 is adopted. Co-sponsors. Representatives Froelich and Epps co-sponsor. Please close the machine. Mr. Shebel, please read the title to Senate Bill 93.
Senate Bill 93 by Senators Cutter and Hawkes Lewis, also Representatives Weissman and Brown, concerning increasing consumer protections in various medical transactions.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 93 on third reading and final passage.
Representative Hartsook.
Thank you, Madam Speaker. We'll get a little huddle here. Due to a snafu and some coordination here, we request permission to propose a third reading amendment to Senate Bill 93.
Representative Weissman.
Thank you, members. So what's going on here is we debated this bill in seconds yesterday. The representative from Douglas County wanted to offer a particular amendment. Things went quickly. He did not have the chance to do so. We talked and agreed that we would allow there to be discussion today on third reading. It's a substantive amendment. We can do that because it's second chamber on third reading. I'm very much against the substance of the amendment. I'll get to that in a minute. But on permission, I'm asking for a yes vote. We don't mind creating a little bit of space for there to be a discussion about an important aspect of the bill. So we're asking for a yes on permission. The amendment's being updated from a second reading amendment to a third reading amendment right now, and we'll get that up on the screen, and we'll get into the merits of it in just a moment. But yes on permission, please.
Members, the question before us is permission to offer a third reading amendment to Senate Bill 93. Mr. Schiebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Please close the machine. With 60 aye, 4 no, and 1 excused, the request for permission to offer a third reading amendment is adopted. The House will stand in a brief recess. The House will come back to order. Representative Hartsook.
Madam Speaker, I move Amendment 008 to Senate Bill 93 and request that it be displayed.
Apparently, handwriting works still. Thank you, Representative Hartsook. The amendment is properly displayed.
Thank you, Madam Speaker. So as was stated earlier, we due to a snafu yesterday, and thus I appreciate the handwriting in here. On the bill, our big concern that we want to discuss further, and we've already, appreciate the consultation with the bill sponsors, and we know their position, but we want to bring this out for the discussion and to bring it to attention, is the 3%. When you look at the bill and you look at the cost of everything that's out there, when we start putting limitations and caps and constraining things, somewhere that has to pop out. Somewhere, when there's pressure put on something, it's going to go somewhere else. And the same goes with finances. We understand that healthcare is out of control and it's getting higher. The problem is when we start putting limits and controls on things, that doesn't solve the problem. What we prefer is watching transparency. We want to see what's out there so people can make a choice and have a comparison and decide what they want to do is the best as the best option to go to. Medical debt is often used or often becomes a burden and leads to bankruptcy. And yet at the same time, we still need to be able to look at things properly and have that debate in the business community as to what we're going to do with it. Because if we simply start limiting things, where does it stop? And that's my primary concern on this. And I appreciate the bill sponsors working with us and giving us this opportunity, but at least willing to hear us out. And that's what I would ask at this point. And I would urge an aye vote on the amendment. Thank you.
Representative Bradley.
Thank you, Madam Speaker. I also would urge an aye vote on this amendment. As a healthcare worker who worked through COVID, who took a 10% pay decrease while working, while getting COVID, while being on oxygen for 5 weeks and still making it to work every day, we struggled as a family. We don't take Medicaid at my clinic or any of the other clinics because the payback is so low. But what I do personally is treat it for free. I treat cases like that for free from the bottom of my heart because I believe as a healthcare worker, it's a charitable thing for me to do. It's right and good to help those in need. That's what we're supposed to do. That's what the Bible tells us to do. We should love those in our community and provide for those that cannot, at a given point in their lives, provide for themselves. But here, we are not providing for them. We are forcing medical service providers and professionals like me to provide for them by capping an interest rate at an amount that is currently below the inflation rate. So see what we're doing to the medical workers that we have an increased shortage of. We have decimated the medical labor force in the state of Colorado. And you can blame it on whatever you want. I saw a decrease after COVID. People were not wanting forced vax, and that's why they left, but you can blame it on whatever you want. It is immoral to force someone else to fill a genuine charitable need. Is a rate above 3% unconscionable? If so, why is it that specific just to the medical community? It's like we're slapping them again. We're just now recovering from taking care of all of your loved ones during a pandemic, and now you're coming after us again. The bigger problem is our healthcare system is not at all based on free market principles. It is highly controlled and convoluted, leading to real financial hardships. What should be done about those with such high medical debt? The answer is to both fix the mangled market while we encourage charity, but do not do charity by compulsion. Most people in medical staff or medical professionals have a part of them that do give back. I have given back more at the rate of my children suffering from me not taking a paycheck home, because that's what healthcare providers believe that they should do. Money through government is not made by magic. It comes from we, the people. We should take care of our neighbors. There is no magic in having the government do it other than the fact that it can force our neighbors to do charity for us or with us. But here, even worse than forcing charity through government, rather than encouraging the space needed to provide for it naturally, we actually go a step further. We're good at that. We don't force that charity on everyone equally. We force it on specific groups. We force the doctors, nurses, physical therapists, hospitals, and anyone else that may substantiate their livelihood through medical payments to do that charity on our behalf. It is not right. It is not right to slap the people that got us through this pandemic and nursed our loved ones back to health to do this to them again. You want to talk about a shortage of labor in the medical world? Let's do this. Let's vote yes on this bill. It is not moral to force someone to do charity for us. It is moral for us to just do it. Anytime we play in the market like this, we artificially pick winners and losers. It's kind of becoming a theme in this place, based on what we decide is fair, and doing so with incomplete facts because it is impossible to know the specifics and fairness or justice of each situation ahead of time. You can't do group justice like this. If we as a society do not love our neighbors, forcing some other subset group to love our neighbors for us does not fix the moral problem. It exacerbates it. I ask you again, why are we picking on the medical people? The people who were there for all of you, who rehabbed you, who got you through knee surgery, who took care of you while you were in the hospital. Now we're going to come after them. We're coming after those people that took care of us during the pandemic. This is a ludicrous bill, and I urge a no vote. Thank you.
Representative Taggart. Representative Bradley.
In my passion, I got confused. Thank you, Madam Speaker. Yes on the amendment.
Representative Taggart.
Thank you, Madam Speaker, and it's an honor to serve with you.
And an honor to serve with you.
There's a great deal about this bill that I do like, but this is the area that I was concerned about from the first time I read this bill. The prime, and perhaps some of this reason for 3% is that perhaps this was written over a period of time before interest rates went up to the degree that they have. I remind everybody in this room today, the prime interest rate today is 8%. I repeat that. It is 8%. And the prime interest is an interest rate that is charged to the best of us that are paying our bills. We can't be charging 3% when the prime is at 8%. That is just illogical. Thank you.
Representative Frizzell.
Thank you, Madam Speaker. I also rise in support of this amendment. You know, I'm very concerned. We've talked a lot over the last several weeks about interest rates on a variety of different things. We've also had conversations around medical debt, and these are important conversations to have. And my concern is, with this bill, is the same as some of the other bills that we've had, and that is we're the picking winners and losers. Like my colleague from Lone Tree indicated, it doesn't feel like there's any rhyme or reason. Most other debt, unless there's some other agreement, is set at 8%, or as my colleague from Grand Junction indicated, higher, because right now, in our inflationary times and with the government's intervention in trying to bring inflation down, we've seen interest rates rise incredibly. So that 3% seems like quite the bargain at this point. But I question, is like, why 3%? Where did that number come from? And I didn't sit in the committee hearings on this particular topic. But why does medical debt get a special treatment? Is the 3% a static average? Is it intended to match historic inflation patterns? And if that's the case, why not link the percentage, the interest rate to inflation? If that 3% is below inflation, like it is now, are there going to be market impacts on the availability of acquiring loans so that you can pay for a medical procedure? So my question is, ultimately, if you need to take out a loan to have a procedure done, and this rate is set at 3%, it's going to be difficult to find that financing at current rates. This is also affected by the time limits for paying the debt off. Because if this interest rate is below what we're currently seeing, the incentive to pay it off is kind of inverted. And that debt becomes forced charity by our medical providers. So I just am concerned about the analysis that pegs this interest rate at 3%. Why not 0? Why not 2? If the intent of this bill is to really help those that need medical services, Why have a percentage interest rate at all? So I do stand in support of this particular amendment and ask for your aye vote.
Representative Winter.
Thank you, Madam Speaker. I also stand in support of this amendment. There's something to be said from what my colleague just spoke about, and that's the incentive to pay off that medical debt. I'm still paying medical debt for both of my daughters. They bestowed me with medical debt, and it's a tough thing. It is. I mean, I'd actually probably have some things if it wasn't for my kids' medical debt. But I also see that cause and effect of if you make the interest rate low enough that it don't encourage people to try to pay that debt. I could see where that'll pile up. And then at the end of the day, when it does become charity and that debt has to be absorbed by the healthcare industry or the healthcare workers, then of course they're trying to make a living. So then that debt's going to be spread across to everybody else. So I urge an aye vote on this amendment. I think it's a good amendment. Thank you.
Representative DeGraff.
Thank you, Madam Speaker. As it's been discussed, with legislation, we're largely imposing, creating morality. And this is creating the morality, well, this is getting rid of the imposed morality of not paying medical debt. Charity is voluntary. What you're looking to do here is make charity compulsory. Because the free market, freedom in the free market, and this is a further forcing of the market, a further foobarring of the market. This market is not free. Here's how you make a difference in charity. Here's how you make a difference in charity. You can make a difference in charity. You can. Or you just put in your earbuds and you don't listen
To the
about
amendment,
free market.
Representative DeGraff.
I am to the amendment. Yes, ma'am. My apologies. This is a forcing by putting a 3% on there, especially when the prime, my colleague said the prime is at 8%. So if the prime is at 8% and your medical debt is capped at 3%, then you have to make a decision in your debt. Who is not going to get paid? So what we're doing is we're telling somebody that has debt that is going to have to make these choices. We're telling them, do not pay your medical debt. Now, the thing with the free market is that you're exchanging value for value. And so in this case, the medical community provided value. Nobody forced you to go to the medical community. Whatever you went for, you went for. I get it. There's not a whole lot of other options, but you did go for some form of value. And if it has a value, then you exchange value. Now, if you don't exchange value and you just make it a compulsory charity exercise on their part, what you're doing is you're chasing the medical professionals out of the field. And then you limit your options. But this is how we do this in here. We're going to impose our morality on them and say, you have to cap your debt, you have to cap what they owe at a 3% interest rate. And then they will say, well, I can't survive at 3% interest rate because that interest rate is a level of pain that has to be maintained by the individual in order to incentivize them to, why 3%? Why not 0%? Why not just force the medical community to float you a loan forever? Why is 3% more moral than 0%? Why doesn't anyone answer the questions? What you're doing is you're forcing the medical out. And so when you force the market to say what you provided has no value, it has low value, you're going to force that option out of the market, and then you're going to say, wow, we don't have medical providers. Why don't we have medical providers? Well, here's why you won't have medical providers, because they're going to go out of business. But you'll feel good about it. because you capped the debt at 3%. They'll be gone, and then you'll say, well, those greedy medical providers, they want to just
Representative
make money.
DeGraff, that has not been stated nor implied. Thank you.
Thank you, Madam Speaker. I'm not sure what we're implying then by capping medical at 3%, because what we're doing is we're saying that our health is valuable, but our health is valuable below any other debt. Our health is less valuable than the debt on our snowmobile or our jet ski or our automobile. Those debts are important. Healthcare debt is not important. We're protecting those debts. This bill is saying, it's not implying, this bill is saying that medical debt is not important, is not as important as the other things that are higher interest rates. So that's not me implying motive, that's the bill stating its direct intent. And the direct intent is to say that medical debt is of less value, that our health is less value than the jet ski, the snowmobile, the stereo system, whatever it is that we want to buy, medical debt is less important. And that's how we lose health care options. It's basic math. It's not even calculus. I recommend voting to keep our health care options and vote yes on this amendment to not signal to the entire industry that we do not value health care. This 3% is a direct signal to the industry that we do not value health care.
Representative Holtorf.
Thank you, Madam Speaker. We understand a few things with respect to the medical industry and health care as we work in the state legislature, and I've sat on the Public Health Committee going on 4 years now. And truly, the one thing I do understand is how heavily subsidized health care is across the country in almost every age group and demographic, with a few exceptions. So youth are subsidized through Medicaid, low-income recipients through Medicaid, and it's a large percentage of healthcare in rural Colorado, north of 50%. Now, this particular amendment is part of that subsidization, continued subsidization by something that I think is very dangerous. It's called price fixing. Now, in the world that I grew up in and the world I believe in, the world I want my kids and my grandkids to grow up in, Madam Speaker, I don't want price fixing. So you ask me, what does that mean? Well, I don't want the government to come in and say, federal, state, that this is the price point and that is the law, because we say so. 3% on medical debt, which is what this amendment is trying to get rid of. It's trying to remove the maximum. And I'm pretty sure that covers lines 2 through 5 on page number. Just want to make sure 2. Yeah, okay. Now, one problem the medical industry has with this is, what if a hospital or clinic has to go get medical equipment? Durable medical equipment. I'll use an example that's pretty close to my home because it's been a conversation at the kitchen table. One of my daughters is an ultrasound scan technician. She works at the Sidney Regional Medical Center in Sidney, Nebraska. We've talked about how close we can get to other states, and people will work across state based on conditions in Colorado that may not be as favorable as conditions in another state. But that's not this bill, Madam Speaker, or this amendment. But my point is that hospital had to buy a new ultrasound machine. Her level of expertise was higher than the machine's capability that they had at that hospital. What do you think the interest rate was on that machine for that hospital? Because I guarantee you they had to go buy it with borrowed capital. You think it was 3%? You think it was 4%? You think it was 5%? One of the smartest guys in our caucus, business-wise, from Mesa County, has already told you the prime interest rate is at 8%. Now, I learned that's the rate that monies, and there are some subprime rates, but that's typical rates that banks will lend other banks. Also, if you have the absolute highest credit rating possible, you may negotiate a prime rate. Most business people like me, it's prime plus 1, 2, or 3 points, depending on your collateral base, your borrowing history, and your credit rating. And every lending institution has a different way to determine their credit ratings. Unlike personal credit, business credit is different. But I guarantee you that machine cost probably north of 8 or 10% to borrow and buy. And these machines are hundreds of thousands of dollars. So in this heavily subsidized world, now Colorado says, well, if you got debt, hospital, clinic, whatever, and you need to collect on it, we're going to price fix that at 3%. Now, if you support this amendment, which I already know the bill sponsors have said they're not excited about, then you don't do that. You don't price fix. Those things will get decided in a different market structure other than the government mandating a price. But, so there's inequity there. The hospital or clinic has to borrow money at 5, 6 points, 8 points higher than their debt collection rate allowed by the state. Who wants to work in that kind of business world? Now, I'm not casting judgment on anybody. I'm just saying in a rhetorical way, if you create these kind of situations, who wants to be in this business environment? When right across the border, you got a whole lot better business environment because you have less government mandates, orders from on high that say we are price fixing this point because we say so. The General Assembly is going to vote on this, the governor's going to sign it, and we're going to stick it in your ear.
Representative Holtorf.
Yes, ma'am.
Please.
Yes, ma'am. Thank you for your leadership. I withdraw that last comment. Nothing's getting stuck anywhere, but it feels like you're getting stuck somewhere. Now, let me continue with this. The reason I like this amendment is because it doesn't create this situation. The perception of it or the reality of it goes away. And we don't do a construct of government that is not a representative, republic, free market, capitalist-based form of governance and using those type of economic principles. It's something else, Madam Speaker, and I'm not going to mention it. I don't want to say what it looks like. But why stop here? If we're okay with fixing price points for medical equipment here, to the bill sponsors, why stop here? There's so many things we could do. We could go to energy costs. We could go to education for our kids. We could go there too. We could go to agriculture. And that world is somewhere thousands of miles away that's in a war against Ukraine. And that's not the United States of America. I'm not going to say what that form of government is or what that economic system is, but it's not American. If you take this to its logical extension, it's something very dangerous, because you can apply this anywhere, in anything. Right here in this state, we could price fix everything. We could vote on it and just do it. Price of airline tickets, price of fuel.
Representative
Yes, ma'am.
Holtorf, you have 1 minute remaining.
So, I'm in support of this amendment because it takes away the conundrum that I just explained. This incremental step as we sneak in, slowly walk into this dangerous place that, in my humble opinion, could extend to anything based on the type of leadership and the makeup of any pluralistic body. So I'll be a yes on the amendment. I think I made my point on where I'm at on the bill. Thank you.
Representative Luck.
Thank you, Madam Speaker. So it's my understanding that CRS Title V sets the default interest rate for most debt absent an agreement at 8%. And that when there is an agreement to increase that rate, it may never exceed 45%. So what I'm wondering about is that by setting a new maximum rate for medical debt, are we incurring some consequences that we may not have considered? For instance, if an individual pays a portion of their medical bills with their credit card, are we now imposing on credit card companies an obligation to ensure that they have protocols in place to be able to distinguish between those purchases that are medical debt and those purchases that are not medical debt, so that they can ensure the limit of 3% for the medical debt elements to be honored by this law? How about individuals seeking loans from banks or for unexpected medical services? Will they find it harder to obtain a loan if those providers do not want to loan out money at 3%? In other words, if people have to go out and not just get those services and then be in a relationship with the medical provider themselves, but actually need to go out to a separate bank and take out a separate loan for that, are they going to find it difficult for them to acquire that? In which case, will they be able to actually pay for those services that they otherwise wouldn't be able to pay for if they didn't have that? Just some questions to the bill sponsor as to how is that going to work in practice now that we're setting a new maximum rate and not a new default rate for medical services. Thank you.
Representative Brown.
Thank you, Madam Speaker. I rise today in opposition to this amendment. I think it's important to know that no one should go bankrupt because of getting sick or injured, and medical debt is different. To my colleague's point from El Paso County, it is exactly different. And that is the reason we are bringing this bill, is because no one should go bankrupt because they get sick or injured. And I mean that even for people who have insurance. When your deductible is $5,000 or $9,000 a month, as many people's are, people carry debt even when they have insurance. I ask for a no vote on this amendment.
Representative Weissman.
Thank you, Madam Speaker. We were yes on permission for the discussion. I'm also a strong no on the amendment. Couple of additional notes on this. This really guts the bill. I mean, basically the bill is procedural and substantive protections concerning medical debt. This is the substantive protection in the bill. It's been carefully arrived at in response to the comments from the representative from Penrose. We grappled with the definition, the key definition of medical debt. As introduced, we were trying to get at credit card debt. It was realized there are challenges in that. How do you differentiate within what's on the credit card statement? So if you look at the version that we're voting on, you'll see that even if it's an otherwise qualifying medical expense charged to a credit card, that is outside of the definition of the bill. A lot of other concessions were made in the Senate, as a result of which the bill had bipartisan support over there. There was no opposition testimony, including to this provision, that I remember in committee. To the idea of free market metaphors, respectfully, I would submit that if you look at what the economic characteristics are of a free market, we don't have one in healthcare, and I don't know if we ever have. One of the characteristics of a free market is ready access to information. We do so many price transparency bills around here because we quite lack free, fluid information about cost in the healthcare sector. Another characteristic of a free market in economic theory is competition. If you look at relevant indices, there's something called the HH index that USDOJ uses to measure market concentration. You will find profound concentration, including in geographic areas of Colorado, in healthcare providers. So again, not another index of there not being a free market. You know, if you navigate to the website of the Farm Service Agency of the U.S. Department of Agriculture, you'll find that you can get a down payment loan to buy a farm at 1.5%. Is that a specter that's haunting Europe, or is that a policy choice? Because we want to stand behind agriculture and agriculturalists. I hope the representative from the Eastern Plains is hearing that. It's a policy choice, and we're making another policy choice in this bill. We're saying that medical debt is different. I'm strongly in agreement with my colleague from Louisville on this point. Concerning mortgage debt, you can choose to not try to upgrade to a bigger home. Concerning automotive debt, you can choose to drive the car that you have. Concerning a home equity loan, for example, you could not do the projects you want to do with that type of loan. When you get cancer, when you get in a car wreck, when you suffer some other sort of medical tragedy, you don't really have a choice. So that's why we say that medical debt is different. That's why we propose this 3% limitation. That's why we strongly ask for a no vote on the amendment. As our colleague from Louisville pointed out, plenty of people find themselves in these debt situations, even who have insurance. So you're paying hundreds, maybe north of $1,000 in premiums for your family. And then you have a deductible that could easily run into the thousands of dollars. And then you have co-insurances that could run tens of percentages. And just due to the complexities in the system, you may still have debt. In finance, there's a rule of thumb called the rule of 72, which is the money is going to double in as many years as your interest rate divided into 72. So at 8%, your debt could run away and double on you in less than a decade. And we know it does that for some folks. By lowering the interest rate to 3%, we give people a little bit more space to not get further behind than they already are. Medical debt is crushing our country, it's crushing our state. This is a pretty carefully calibrated measure to try to provide some relief to all of our constituents, regardless of what district that we live in. For that reason, we ask for a no vote on the amendment to keep the bill intact. Thank you.
Seeing no further discussion, the motion before us is the adoption of L008 to Senate Bill 93. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
No.
Representative Epps votes no. Representative Froelich, how do you vote?
No.
Representative Froelich votes no. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Representative Vigil, how do you vote?
No.
Representative Vigil votes no. Please close the machine. With 21 aye, 42 no, and 2 excused, the amendment is lost. To the bill, Representative Bradley.
Oh, just thank you, Madam Speaker. You know, when I sit in the committees that I'm on, and I listen to us trying to pass bills on mental health for kids and why can't we do this and inpatient residential treatment health center or health treatment centers. What's wrong? Why can't we do this? The number one answer is we can't find the health care for it. We can't find the nurses. We can't find the staff. So when you guys are sitting on these committees and the nurses have run the other way and the doctors have left because we've now capped what they can collect, hope you pay attention to that. Lawmakers stress urgency of healthcare worker shortage. Addressing the education pipeline is one thing that legislators could focus on to improve nurse and physician shortages, medical school and health system leaders. This quotes that this country is facing a shortage, this was just published February 16, 2023, of up to 124,000 physicians by 2034, including 48,000 primary care physicians, according to the Association of American Medical Colleges. An analysis in Colorado showed that we'll be facing a shortage of 54,000 healthcare workers and more than 10,000 registered nurses by 2026. So think about that. Think about that. We're already in a healthcare worker shortage. All the bills you're trying to pass for mental health of children and everything else that we're trying to do, we cannot do because we don't have the staff to do it. So now let's limit the medical debt to 3%. So doctors go to a different state. So that physical therapists go to a different state. I am tired of legislation picking winners and losers. And right now, sure, this helps the consumer. I'm a consumer. I have 4 children. Sometimes I'm on a health insurance plan with a very high deductible and a very low copay and coinsurance in hopes that maybe that year my kids don't get too sick. We all have to pick the plans that we're a part of. I've spent $50,000 in medical debt before. I've had to work a second job. It was the price that I took on by picking a higher deductible and a lower premium. I didn't find the fault at the expense of the doctors providing the care to my children or the healthcare workers that were treating me or my children. That's what this bill does. We're making the healthcare providers sacrifice so that you don't have to pay on a lifelong debt. We're going to have them pick up shop and go somewhere else. And in the midst of all this, I've listened to all these testimonies where we're passing bills to help educate nurses and incentivize optometrists and incentivize PAs and incentivize psychologists to be able to write prescriptions, to incentivize them to come to Colorado and help out in rural Colorado. Incentivize them. And now we're going to say, hey, thanks for coming, but we're not going to make people pay the debt that they would have to pay on a house or other choices that they've made. Getting health insurance is still a choice. I hate paying the big deductibles. Still a choice. You still have a choice to do it. This bill is not right to tell our doctors and healthcare providers that work tirelessly through a pandemic. It's not right. It's not right to me. It's not right to the people that I work with. We're exhausted. We're tired. We took significant pay cuts to keep our companies afloat so that we could treat all of you. This is not right. This is picking winners and losers, and the healthcare industry is the losers. I urge a no vote on this bill. Thank you.
Representative DeGraff.
Thank you, Mr. Chair. I disagree with my colleague. This is picking winners and making losers. The losers are the healthcare. Medical debt is different, and this ensures that it's a lower priority. It ensures that every single debt that you have is a higher priority. Every single one. This part down here, we just talked about the amendment, that's gone. Medical debt does not include debt that's charged to a credit card. So nobody's going to pay their medical debt on a credit card because that's going to be up like 18%. So Gucci bags, those go on the credit card. Those have to be paid. But you're not going to need to worry about your medical debt. You could, as I said before, because charity is a voluntary act. This is compulsory charity, which is not really charity anymore. It's just compulsory. You could create a bank. Because there's such a demand for this, you could create a bank and say, this bank is for taking medical loans and we'll cap it at 3%. How many bankers do you think you'll get that will voluntarily loan money at 3%? Below prime. How many? How many are going to take that? So what we're doing instead of our personal altruism to solve this crisis that could be handled by personal altruism, we're going to assign it, and we're going to tell the medical facilities that what you do to make people well is not enough. You also need to float them loans at 3%. So ironically, the ACA, the Affordable Health Care Act, doubled and tripled costs, doubled and tripled deductibles, created more of a forced market. So that's legislative bodies forcing the market, creating a FUBAR market, making this completely untenable. Now we're going to say to this same body, and we're going to say, you have to do this. You have to fix our problem. You have to fix the problem that legislation created, and you have to loan money at 3%. Guess how many banks will go under if you tell them that they have to loan money at 3%? All of them. Guess how many hospitals will go under if they become bank lending institutions that have to loan money at 3%? Oh, but we can pass legislation based on the laws of wishful thinking, and then those laws of economics 101, they don't apply. So we tell the medical professional that thank you, but no thank you. What you did for us in fixing our health is not as important as my Xbox. I got to pay off my Xbox. Why is medical health, we tried to talk about this yesterday a little bit. Why is medical care so expensive? Well, one of the reasons is on the transparency side. When Medicare, TRICARE, our single health payer providers, they pay about 20% of list price. That drives a 500% list price. So when our government agencies force the market and say, well, we're only going to pay 20% because that way we can tell the taxpayers how much they save, that means the providers have to mark up their cost by 500% in order to break even. So then they mark it up 500% so they can break even, and then the customer goes in and they get the full 500% markup. That's a huge place where they get the debt. So do we fix the problem that the government created? No. We just legislate over the problem that we created and force the problem onto somebody else. But the laws of wishful thinking allow us to do that. So we could, and then ironically with that 500% list price, then you get a 20% copay, which is actually what the procedure cost in the first place. So because of the single-payer health care system that we all end up paying huge deductibles, huge prices, and then we still pay for the health care. But we don't fix the problem that the government created, we just create more problems. Because there is no problem that the government can't make worse with a solution. My colleague said we don't have a free market in healthcare, and that is 100% true. So probably what we ought to be doing is looking at freeing the market in healthcare instead of continually trying to cut its head off. It's the golden goose. And we're going to try to extract. So I'm going to be curious as to know from my colleagues why they don't start a bank out of their own altruism, get some good lenders behind them, get some good force behind them. There's a lot of moral. I mean, you got tons of people out there that would be, they want to make this happen, so just get all their money and they can loan it out at 3%. At 2%, because you probably should make 1% on the bank. So why is the solution to force, why is the solution here? And I noticed that medical debt, again, doesn't include credit card debt. So we specifically carve out that. So we're going to say, do not put your medical debt on your credit card because that's going to be at that 18% interest. So we're deprioritizing. I do appreciate my colleague mentioning the rule of 72 and the debt will double at 8%, but that's how we do our budget with mandatory spending, and so we double our spending every 20 years or so. That's true. When we put our mandatory spending on an upwards curve with a 1% plus inflation, 3% plus inflation, it doubles every 20 years. So we're short of physicians. We're going to chase them out of the state. We have a healthcare crisis, and we're going to make it worse. And then we're going to tell our constituents that it's those, well, I can't say, yeah, well, never mind. This is the road to hell.
Representative DeGraff, thank you. Representative Hartsook.
Thank you, Madam Speaker. Smile. I'll close this out. You know the bill, what it says, increasing consumer protections. And that's what the bill does. The bill increases consumer protections. But at whom's expense? I submit for your consideration that this bill is one more nail in the coffin for small business healthcare providers. Independent providers that have a small practice struggle with debt collection. They struggle to pay their staff. When things are turned over to debt collections, it takes many months before they even get to that step. And that's usually many months after that the service has been provided. Meanwhile, that business has had to pay its bills, pay its staff, and pay its debts. But it cannot collect on the care that it's provided to the consumer, to the patients. And this bill is providing patients, as it says, debt relief. But who provides debt relief to the healthcare provider? Who provides debt relief to the businesses that are servicing that healthcare provider for the supplies that are used and those treatments. This are the unintended consequences of a bill like this. These are the real world that will impact real people, real doctors, real healthcare providers that are out there. And many of them are frustrated. Talking with many organizations out there, they see it coming from every angle. And they are very frustrated because every time they turn around, there's more legislation that hinders their ability. This impact to a hospital will be shifted in cost sharing to some other venue where it will be collected, but not for the independent small business healthcare provider. You think of your little private doc that you go see, or the dentist, somebody that's not affiliated with corporate America. They hang their shingle, they went to school, got their degree, did their student loan, they're paying off their debt, but now when it comes time to collect debt from somebody they've provided services to, they run into big limitations. That is neither fair nor equitable. Every person has a responsibility to pay their debt. And if you're unable to pay your debt, then there's court remedies. We have a system that allows for bankruptcy. And everybody says, well, why should we have to do that? That is what is allowed by the courts if you can't pay. For whatever reasons, the court decides that, and they'll set up payment plans and restructure, and they will do their job. But those small businesses that provided that health care are out of luck. It is becoming to the point where there is more business being written off because the cost to try to recoup it exceeds the effort to get it done. And this bill is telling consumers, oh, if you get too much, you don't have to pay your debt to the healthcare provider. Yet that healthcare provider still has to pay their debts. So where is the equity in that? Where is the just cause in that? That one person is relieved of their debt and someone else must absorb it? I totally disagree with that. I appreciate the sponsors letting us work through the things of yesterday when we didn't have the discussion to have it today. I do appreciate that. We've made our point known down here. My concern is, like I said, this becomes the nail in the coffin to small business healthcare providers, and they are becoming fewer and fewer because when they come out of college with debt, they are looking at having to go into business and that cost, and then all of these regulations on top of it, and many are saying no. They look for a different state, or they simply go to a hospital and work their time on a salary. And then we lose that community involvement. And I don't think that's right. I urge a no vote on the bill. Thank you for your time.
Representative Martinez.
Thank you, Madam. Thank you, Madam Speaker. I had to find the right microphone. I'm a bit short, so. So members, I wanted to tell you a story, and I received permission from this veteran to tell it, where Senate Bill 2393 would really be effective and have prevented this incident from happening. There's a disabled veteran that lived in my district, or lives in my district, and it gets all of his medical care paid for through the VA. This veteran needed some diagnosis and had to go into a local facility in order to get an x-ray exam that needed to be sent over to the VA. Unfortunately, that company that does the x-ray, because that was not provided through the hospital, was provided through a third-party company. Veteran got the care needed, sent off to the VA. Well, that company decided not to send that bill out to the VA for a year and a half. So once the VA finally did get the bill a year and a half later, VA said, well, we're not going to pay this because this is well outside of our scope of duties. And so they said, no, we're not going to pay this third-party company for executing that x-ray. Third-party company said, well, VA is not paying for it, so guess who is paying for it? We're going to stick it on that veteran, that disabled veteran. And within 30 days after a year and a half of waiting for that bill, that veteran got a debt collection letter, and 30 days after that, it was sent to collections. That's unacceptable. And the only reason why that veteran was able to not getting stuck with these ridiculously large payments or an effect on his credit is because he luckily got the one very kind operator that day that said, I recognize the situation, I'm going to help you. You still have to pay it, but we're going to do it at a 0% interest. Had that veteran not gotten that person on the phone that day, credit would have been ruined, paying ridiculous amounts of money for a procedure that should have been paid for by the VA. And I'm not blaming one person or another on this. This is a loophole that fell through. But Senate Bill 93 would have helped prevent that, or at least given some buffer time to being able to help that veteran resolve the issue and hopefully not had to do this and have the responsible party pay for that. So I rise in support of this bill, and I urge an aye vote.
Representative Bradley.
Thank you, Madam Speaker, and thank you to the representative from the San Luis Valley. I agree. Why not make a bill that veterans only have to pay 3% of their medical debt back in the rate? Sorry, it's been a long day. Why are we taking the whole group of medical providers and going after them? That is the question. Why are we making them reap what we sow? It is not fair to medical providers. And most of the time, listen, I've got thousands of dollars in debt. You work with a hospital. You can work with my company. I am a small business owner as a physical therapist. You can work with my company. I'm not making millions of dollars. I'm making a little less here, but barely. I'm not rolling in the money. Most medical health or medical providers are not doing that. We do it because we love to help others. So let's bring a bill for veterans, but you don't get to punish all of the other healthcare providers by minimizing what they get to collect. That's not right, and it's not fair. It's not fair to small business owners. It's not fair to our medical professionals. I urge a no vote on this bill. Thank you.
Madam Majority Leader.
Thank you, Madam Speaker. Per House Rule 16, I move the following motion. Shall the main question be now put?
For your information, an affirmative vote on this motion ends any further debate on the issue before the House. We will vote on this motion, and if the vote is majority yes, then we will immediately vote on the underlying issue before us. The question before the House is, shall the main question be now put? Mr. Schiebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Please close the machine. With 44 aye, 19 no, and 2 excused, the motion is adopted. The question before us is the passage of Senate Bill 93 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Please close the machine. With 43 aye, 20 no, and 2 excused, Senate Bill 93 is adopted. Co-sponsors. Representative Epps, Froelich, Morrow, Vigil, co-sponsor.
She got her. She's on there.
Please close the machine. Mr. Shebel, please read the title to Senate Bill 144.
Senate Bill 144 by Senator Janal, also Representatives Mabry and Young, concerning prescription drugs for the treatment of chronic pain.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 144 on third reading and final passage.
The motion before us is the adoption of Senate Bill 144 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Bockenfeld. Please close the machine. With 44 aye, 19 no, and 2 excused, Senate Bill 144 is adopted. Co-sponsors. Representative Epps and Froelich, co-sponsor. Please close the machine. Mr. Shebel, please read the title to Senate Bill 85.
Senate Bill 85 by Senator Winter F., also Representatives Hamrick and Story, concerning the continuation of the Sexual Misconduct Advisory Committee and in connection therewith implementing the recommendations in the 2022 Sunset Report by the Department of Regulatory Agencies.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 85 on third reading and final passage.
Seeing no further discussion, the motion before us is the adoption of Senate Bill 85 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Please close the machine. With 59 aye, 4 no, and 2 excused, Senate Bill 85 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to Senate Bill 162.
Senate Bill 162 by Senators Willen, Hawkes, Lewis, also Representatives Lindsay and Tatone, concerning increasing access to pharmacy services.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 162 on third reading and final passage.
The motion before us is the adoption of Senate Bill 162 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Yes. Representative Vigil votes yes.
Yes.
Representatives Bachenfeld, Basenecker, and Holtorf. Please close the machine. With 52 aye, 11 no, and 2 excused, Senate Bill 162 is adopted. Co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1213.
House Bill 1213 by Representatives Young and Bradfield, also Senator Mullica, concerning the distribution of Stop the Bleed materials to schools and in connection therewith making an appropriation.
Madam Majority Leader.
Madam Speaker, I move House Bill 1213 on third reading and final passage.
The motion before us is the adoption of House Bill 1213 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Ortiz. Please close the machine. With 57 aye, 6 no, and 2 excused, House Bill 1213 is adopted. Co-sponsors. Representative Vigil co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1231.
House Bill 1231 by Representatives McLaughlin and Puglisi, also Senators Marchman and Lundin, concerning improving mathematics outcomes in pre-kindergarten through 12th grade education and in connection therewith making an appropriation.
Madam Majority Leader.
Madam Speaker, I move House Bill 1231, no, sorry. I move House Bill 1231 on third reading and final passage.
The question before us is the adoption of House Bill 1231 on third reading, final passage. Representative DeGraff.
Thank you, Madam Speaker. I don't really have a whole lot to say on this because as a STEM instructor, this is definitely needed because the STEM skills that our students are showing up at college with are low. But we're going to spend $25 million. It's going to cost us $25 million to dig out of a hole that was created by legislation with Common Core standards and the pandemic response. So, the one thing I like about this bill, well, I mean that maybe we can dig our students out of the hole that government created, is the acknowledgement, tacit acknowledgement, that government created this problem in the first place.
Seeing no further discussion, the questions before us is the adoption of House Bill 1231 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
No.
Representative Froelich votes no. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
No.
Representative Vigil votes no. Representatives Holtorf and Weinberg. Please close the machine. With 51 aye, 12 no, and 2 excused, House Bill 1231 is adopted. Co-sponsors. Please close the machine. Mr. Schiebel, please read the title to Senate Bill 182.
Senate Bill 182 by Senators Zenzinger and Kirkmeyer, also Representatives Burton Puglisi, concerning the temporary suspension of certain statutory requirements for medical assistance programs.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 182 on third reading and final passage.
The motion before us is the adoption of Senate Bill 182 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Madam Speaker, can I pass? I need just 1 second.
Yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Epps.
No.
Representative Epps votes no. Please close the machine. With 56 ayes, 7 no, and 2 excused, Senate Bill 182 is adopted. Co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1246.
House Bill 1246 by Representatives McCluskey and Puglisi, also Senators Buckner and Will, concerning measures to support the in-demand career workforce and in connection therewith making an appropriation.
Madam Majority Leader.
Madam Speaker, I move House Bill 1246 on third reading and final passage.
The motion before us is the adoption of House Bill 1246 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Please close the machine. With 56 ayes, 7 no, and 2 excused, House Bill 1246 is adopted. Co-sponsors. Please close the machine. Madam Majority Leader.
Madam Speaker, I move to proceed out of order for consideration of Senate amendments to House bills.
Seeing no objection, we will proceed out of order to consideration of Senate amendments to House bills. Mr. Shebel, please read the title to House Bill 1195.
House Bill 1195 by Representatives Michelson, Janae, and Soper, also Senators Janal and Kirkmeyer, concerning the operation of automated pharmacy dispensing systems.
Representative Soper.
Thank you, Madam Speaker. I was looking for my co-prime, and I realized she's not here. In the Senate, they did make further amendments concerning when a controlled substance is going to be in one of the automated machines, when they're next to a pharmacy, and when the pharmacy is closed. So it really was just some clarifying, and we would ask for a concurrence vote, or a yes vote.
The motion before us is to concur with Senate amendments on House Bill 1195. Seeing no further discussion, Mr. Shebel, please open the machine and members proceed to vote. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Woodrow's excused. Please close the machine. With 59 aye, 3 no, and 3 excused, the motion is adopted. Madam Majority Leader.
Madam Speaker, I move for the repassage of House Bill 1195 as amended.
The motion before us is the adoption of House Bill 1195 as amended. Mr. Shebel, please open the machine and members proceed to vote. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Please close the machine. With 59 aye, 4 no, and 2 excused, House Bill 1195, as amended, is repassed. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1126.
House Bill 1126 by Representatives Ricks and Weinberg, also Senator Exum, concerning the inclusion of certain items of information in consumer reports and in connection therewith, prohibiting the reporting of medical debt information by consumer reporting agencies, prohibiting debt collectors and collection agencies from falsely representing that medical debt information will be included in a consumer report, or failing to timely disclose that with certain exceptions, medical debt will not be included in a consumer report and make an appropriation.
Next time you have to do that all in one breath. Representative Ricks.
Thank you, Madam Speaker. We move to concur with Senate amendments to House Bill 1126.
Please proceed, Representative Ricks.
Thank you. So the Senate made 3 amendments to 1126, impacting the way that medical debt will be collected. One of them was to specifically go after debts that have medical credit cards that have medical debt. The other thing is that the governor wanted to do a study for 5 years, after 5 years of collecting this data, to see if it would adversely impact medical debt. in Colorado. So we ask for your yes vote.
Representative Weinberg?
No, I'm good.
Okay,
said it
we're
all.
good. The motion before us is concurrence with Senate amendments to House Bill 1126. Mr. Shebel, please open the machine and members proceed to vote. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Epps, how do you vote?
No.
Representative Epps votes no. Please close the machine. With 43 aye, 20 no, and 2 excused, the motion to concur is adopted. Madam Majority Leader.
Madam Speaker, I move for the repassage of House Bill 1126 as amended.
The motion before us is the adoption of House Bill 1126 as amended. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Please close the machine. With 44 aye, 19 no, and 2 excused, House Bill 1126 is repassed as amended. Co-sponsors. Representative Epps, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1099.
House Bill 1099 by Representatives Vigil and Weissman, also Senators Fields and Exum, concerning tenant screening documentation for residential leases.
Representative Weissman.
Thank you, Madam Speaker. We move to concur with Senate amendments, and my co-prime sponsor from Colorado Springs actually asked if everybody could gobble extra loud because she wants to be able to hear it too on the wall.
Please proceed, Rep. Weissman.
Thank you. The Senate actually caught something here. All that the Senate changed was an internal cross-reference. It said when we sent it out of here 1.5C, the correct reference was 1.5 sub E. That's it. We ask for a yes vote on concurrence.
The motion before us is to concur with Senate amendments to House Bill 1099. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Catlin. Please close the machine. With 47 ayes, 16 no, and 2 excused, the motion to concur is adopted. Madam Majority Leader.
Madam Speaker, I move for the repassage of House Bill 1099 as amended.
Representative DeGraff.
Thank you, Madam Speaker. Just as an personal adage, if good intention was a good idea, wouldn't need a gun. This appropriation has no appropriation because it is an unfunded mandate. It is requiring a landlord accept a screening, and my if that screening was up to the landlord's intent, then they would have the option of using it, and they would probably want to use it. But by forcing the use of this screening, which doesn't seem to be really all that forthcoming as to what it is, how it's going to be done, what it's going to entail, we're just saying that it has to be done, that the landlord has to accept it, that the landlord has to put his property into the market based on something that, again, we are giving a blank check to, that we don't know. So you're asking somebody you're imposing on their Fifth and 14th Amendment rights regarding their property, the use of their property, and you're putting a stipulation on it. The word requires, and I don't know. The just powers of this body are derived from the consent of the governed. I could do the whole thing. We hold these truths to be self-evident, that all men are created equal, endowed by their Creator with certain unalienable rights. And this does
Representative
speak to the
DeGraff
bill.
to the bill.
Well, it is to the bill because it is regarding our just powers. But I will skip to the end, that our just powers are derived from the consent of the governed. So I have a problem here when the first line of the summary says requires. This bill requires, this bill mandates, this bill puts it into law that will be enforced by law enforcement. Why is it a law if it won't be enforced? Who ultimately enforces the law? So I see heads shaking. But what happens? What happens if somebody decides not to use that? Then they get hauled to court? Because it's a law. Because we're putting more and more and more laws. And we're doing this with a good intention of making rent more affordable. And we're making the act of being a landlord, of providing a place to rent, we're making that more and more odious. Now I know the laws of wishful thinking, they all take this all away, and landlords won't mind a bit. But what happens when the landlords find out that this screening mechanism really doesn't screen for what they want to screen for? What if they determine that some ideologue, because this is going to be under the executive branch at the state level, and they determine that this screening mechanism is not sufficient for something that they want to put their property under, and that the screening mechanism just starts leaving out certain data, because that data might preclude somebody being comfortable with renting to them, so with putting them under of leasing to them. And then so the government comes in and forces somebody to rent their property. And I know this is all done away with the laws of wishful thinking, but I'm just not a believer. So once again, in order to fix a problem that the government created, we're just going to strip away a little bit of the Fifth and 14th Amendment rights of our constituents, of the Coloradans. We're just going to take a little bit, we'll just take all of it. We'll just take all of the Fifth and 14th Amendment rights of Coloradans, because we can. It's not hyperbole. Yeah, vote for it. Feel good about it. It's a very difficult question why somebody would continue renting property in this state. But we'll just keep saying it doesn't matter. It's an excellent question why somebody would rent property in this state. Why somebody would be a medical professional in this state. Lots of questions. So the bill requires just powers derived from the consent of the governed. That's not a just power. That means voting for this bill is the execution of an unjust power, at least according to the oath you took.
The motion before us is the adoption of House Bill 1099 as amended. Mr. Schiebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Please close the machine. With 43 aye, 19 no, and 3 excused, House Bill 1099 as amended is repassed. Co-sponsors. Representative Epps, co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1015.
House Bill 1015 by Representative Byrd, also Senators Liston and Hansen, concerning the taxation of tobacco products.
Representative Byrd.
Hello, Madam Speaker. I move that the House concur with Senate amendments.
Please proceed.
It's a good move, my friends. So in the Senate, there was a definitional change to manufacturer list price, and that would be subject to taxation. We made clear that the manufacturer list price that tobacco products is exclusive of all discounts and rebates. So I ask for a yes vote. This was important because we want to make sure we're in compliance with constitutional law, that we aren't discounting the base price of tobacco products upon which taxation is based. And so the change is necessary to make sure we're in compliance. I urge a yes vote.
Seeing no further discussion, the motion before us is concurrence with Senate amendments to House Bill 1015. Mr. Schiebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Ricks. Please close the machine. With 47 aye, 15 no, and 3 excused, the motion to concur is adopted. Madam Majority Leader.
Madam Speaker, I move for the repassage of House Bill 1015 as amended.
The motion before us is the adoption of House Bill 1015 as amended. Mr. Schiebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
No.
Representative Epps votes no. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Vigil, how do you vote?
No.
Representative Vigil votes no. Representative Hamrick, we need you to vote. Please close the machine. With 39 aye, 23 no, and 3 excused, House Bill 1015 is is repassed as amended. Co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1025.
House Bill 1025 by Representatives Taggart and Michelson Janae, also Senator Rich, concerning extension of charter school applications.
Representative Taggart.
Thank you, Madam Speaker. I move to concur with the Senate amendment for House Bill 1025.
Please proceed.
The Senate moves a little bit slower than we do here in the House, and they ask for an additional year that it starts in year 2025 as compared to 2024, and I ask for a yes vote.
Seeing no further discussion, the motion before us is concurrence with Senate amendments on House Bill 1025. Mr. Schiebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
No.
Representative Epps votes no. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Taggart. Please close the machine. With 57 aye, 5 no, and 3 excused, the motion to concur is adopted. Madam Majority Leader.
Madam Speaker, I move for the repassage of House Bill 1025 as amended.
The motion before us is the adoption of House Bill 1025 as amended. Mr. Schiebel, please open the machine and members proceed to vote. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Froelich, how do you vote?
No.
Representative Froelich votes no. Representative Epps, how do you vote?
No.
Representative Epps votes no. Please close the machine. With 47 aye, 15 no, and 3 excused, House Bill 1025 as amended is repassed. Co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1168.
House Bill 1168 by Representatives Sharbini and Joseph, also Senator Winter, concerning legal representation and due process complaint hearings for the parents of a student who may be eligible for special education services and in connection therewith making an appropriation.
Representative Sharbini.
Thank you, Madam Speaker. We got a Senate amendment. We did not lament it. We hope that you can see that we should all agree. The change causes no troubles, so give us all your gobbles.
Representative Joseph.
Thank you, Madam Speaker. We move to concur with Senate Amendment L02 to amend page 3, line 27, to strike shall to may.
The motion before us is to concur with Senate amendments to House Bill 1168. Thanks for the poetry. Mr. Schiebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
No.
Representative Epps votes no. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Garcia. Please close the machine. With 58 aye, 4 no, and 3 excused, House Bill 11, the motion to concur with House Bill 1168 Senate amendments is adopted. Madam Majority Leader.
Madam Speaker, I move for the repassage of House Bill 1168 as amended.
The motion before us is the adoption of House Bill 1168 as amended. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Please close the machine. With 59 aye, 3 no, and 3 excused, House Bill 1168 is repassed as amended. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1095.
House Bill 1095 by Representatives Woodrow and Lindsay, also Senators Hendrickson and Winter F, concerning prohibiting the inclusion of certain provisions in rental agreements.
Representative Woodrow.
Thank you, Madam Speaker. Colleagues, we're back with no shame in our game. Asked the Senate not to fiddle, but it did just the same. Oh, they added some language. Just check your bill folders. They tweaked a few clauses in a nod to stakeholders. So let's hear it, folks, on this fine occurrence. Gobble your hearts out. We move for concurrence.
Representative Lindsay.
Thank you, Madam Chair. I thought the bill left the House in pretty good shape, but we concur with this, and how lovely to have such a poetic partner. Thank you.
Well, thank you, Rob.
Seeing no further discussion, the motion before us is to concur with Senate amendments to House Bill 1095. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Please close the machine. With 43 aye, 19 no, and 3 excused, House Bill 10, the motion to concur with Senate amendments on House Bill 1095 is adopted. Madam Majority Leader.
Madam Speaker, I move for the repassage of House Bill 1095 as amended.
The motion before us is the adoption of House Bill 1095 as amended. Mr. Shebel, please open the machine and members proceed to vote. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Please close the machine. With 39 aye, 23 no, and 3 excused, House Bill 1095 as amended is repassed. Co-sponsors. Representative Vigil, co-sponsor. Please close the machine. Mr. Shebel, please read the title to House Bill 1183.
House Bill 1183 by Representatives Judah and Sirota, also Senator Winter, concerning Medicaid prior authorization requests for a step therapy exception and in connection therewith making an appropriation.
Representative Judah.
Thank you, Madam Speaker. I move to concur with Senate Amendment to HB 231183.
Please proceed, Representative Sirota.
Thank you, Madam Speaker. Members, for anyone who was in health and insurance, the one change that was made in the Senate was brought up in committee. We didn't make a change at that time, but the Senate did add that amendment related to biosimilar drugs, adding it to the list of generics and interchangeable biosimilars as categories of drugs that the department could still allow people to require to use if they don't get prior authorization. So we worked it out, and we ask for your support.
Seeing no further discussion, the motion before us is the concurrence with Senate amendments to House Bill 1183. Mr. Schiebel, please open the machine and members proceed to vote. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Please close the machine. With 59 aye, 3 no, and 3 excused, the motion to concur is adopted. Madam Majority Leader.
Madam Speaker, I move for the repassage of House Bill 1183 as amended.
The motion before us is the adoption of House Bill 1183 as amended. Mr. Schiebel, please open the machine and members proceed to vote. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Please close the machine. With 57 aye, 5 no, and 3 excused, House Bill 1183 as amended is repassed. Co-sponsors. Please close the machine. Madam Majority Leader.
Madam Speaker, I move the following bills be added to the special orders calendar at 4:55 p.m. House Bill 1155, 1182, 1245, 1102, 1272, 1261, 1262, 1263, 1275, 1250, 1280, 1268, 1162, and 1259.
Madam Majority Leader, I believe there was a mistaken bill title called.
Oh.
Should be House Bill 1276, not 1272.
Thank you, Madam Speaker. I correct that to 1276.
Members, the bills listed by the Majority Leader will be made special orders at 4:55 p.m. Representative Kipp. Members, you have heard the motion. Seeing no objection, the House will now resolve itself into the Committee of the Whole for consideration of special orders. Representative Kipp will take the chair.
so funny that we talk about committee reports before we talk about the bill. Yeah. Let's try that again. Okay. The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen and in your iPads. Bills will be laid over upon motion of the majority leader, and the coat rule is most definitely relaxed. Madam Majority Leader. Madam Majority Leader.
Thank you, Madam Chair. I move to lay over Senate Bill 60 until tomorrow.
Okay, Senate Bill 60 will be laid over until tomorrow. Madam Majority Leader.
Madam Chair, I move to lay over House Bill 1161 until tomorrow.
And so Senate Bill 60 will be laid over until tomorrow, and HB 1161 will be laid over until tomorrow?
Tomorrow.
Tomorrow. Okay, thank you very much. And Mr. Shebel, will you please read the title of HB 23-1155?
House Bill 1155 by Representatives Weissman and Bacon concerning the advisement of rights during a custodial investigation.
Thank you, Representative Wiseman.
Thank you, Madam Chair. We move House Bill 1155 and the Judiciary Committee report.
Okay, thank you. Hold on. Okay, I do see a judiciary report. I'm sorry, I wasn't sure I saw that. Yeah, to the judiciary report, Representative Wiseman.
Thank you. So members, briefly what the bill seeks to do is to provide an independent state statutory basis for what we know as Miranda rights. That turns out to be a little bit more complicated to do, at least in brief form, than you might think. So we adopted 2 amendments in Judiciary Committee in close consultation with attorneys both from the Public Defender's Office and the District Attorney's Council. We're happy to say that on the strength of those amendments to add a declaration and to just restate a bit of the substance in the bill, we earned a 13-0 vote out of the committee, so we ask for your adoption of the Judiciary Committee report.
Thank you. Representative Soper.
Merci. Thank you, Madam Chair. I also wanted to talk to the committee report as well because we did make some substantial changes with the committee report, and it's really important that we understand what those changes are. First of all, it addressed the concerns, as Representative Weissman just said, of the district attorneys. It further made clear that Miranda, which is a caution that's given before an interrogation can proceed of your rights, that case law is fully incorporated into Colorado law. And this is important because of the Supreme Court decision of Vega against Takoya, which in that case, the Supreme Court put Miranda warnings on very shaky ground. And it's very important that as a state we act now to be able to codify the Miranda warning as it currently exists in case law into state law so that it's out there. It's not something separate under state law, but it's a reflection of the current state of the case law. And this is just very important as a matter of citizens' rights before they are going to be interrogated by officers of the state. Because anytime that your right to liberty is put in peril and you're being interrogated over that, you need to know what your rights are. And that's been so important that even in committee we talked about how other nations such as France or Spain have actually had to correct their citizens when they say, I wasn't told you have the right to remain silent. Anything you say after that, can be used against you in a court of law. And those courts have actually had to remind those foreign citizens that you picked that up from American TV and movies. But that's how strong it's been that globally, this is probably one of the most important rights that citizens have in America that other citizens around the world would love to be able to have these same rights. I'm a strong yes. As a matter of fact, I was an original co-sponsor. Can't say enough good things about this.
Thank you, Representative Bacon.
Thank you, Madam Chair. We urge an aye vote on the committee report.
Thank you. Representative Evans?
Thank you, Madam Chair. And I also just want to talk about this bill very briefly. As was originally...
Representative Evans, are you talking about the bill or the committee report?
Correct, the committee report.
Okay.
As it was originally introduced, I had some concerns about it, but in committee, there were some amendments that were brought to this bill that really helped to assuage some of my concerns. I think we've already had some conversations about what Miranda is. And the interesting thing to note with Miranda is that that's a Supreme Court case. And then as that case law has grown and developed over the years, there's become just this whole body of law and case law associated with it. And the concern was that as originally introduced, all of that case law would be lost. However, in committee, through some good conversation and some good amendments, there were amendments that were brought to this that ensured that that case law would be preserved, and that I think it actually says it in here, rough paraphrase, what we're trying to do is codify Miranda in conjunction with all of the supporting case law, no more and no less. And to me, that was critically important because literally everything that law enforcement does on a day-to-day basis hinges back to this court case and then the hundreds and hundreds of pages of case law that have been developed over the years to govern things like there's a booking exception. If you arrest somebody, normally, if somebody's in custody, you can't ask them questions about the crime. However, case law recognizes that, look, you may need to ask them a question about their name or their address in order to fill out paperwork. And so there's certain key components of case law that were included in the committee reports that moved this to a much better place. I was very thankful to the sponsors for being receptive to that and not throwing out all of those hundreds of pages because that was really quite helpful in ensuring that this didn't completely upset the apple cart and take us decades back to when Miranda had been passed without any of that evolving and supporting case law. I made a lawyerly joke in committee, which if you're a lawyer, I can tell it to you off to the side. I think some folks appreciated it, but I won't say it here. But it was a pretty funny lawyer joke. So I asked for an aye vote on this committee report.
Thank you. Is there any further discussion on the committee report? Seeing none, the question before us is the adoption of the judiciary report to HB 23-1155. All in favor, please say aye. Aye. All opposed, no. The judiciary report passes. Representative Bacon, to the bill, Representative Bacon.
Thank you. Most of this bill was discussed in the committee report. This bill codified Miranda and no more or no less than the current Supreme Court case law. We urge an aye vote on the bill.
Thank you. Is there any further discussion on HB 23-1155? Seeing none, the question before us is the passage of HB 23-1155. All in favor, please say aye. Aye. All opposed, no. HB 23-1155 is adopted. Mr. Shebel, can you please read the title of HB 23-1182?
House Bill 1182 by Representatives Epps and Mabry, also Senators Fields and Gardner, concerning a requirement for remote public access to observe criminal court proceedings.
Thank you. Representative Epps.
Thank you, Madam Chair. We move House Bill 23-1182 and the House Judiciary Committee report.
Okay, those have been properly moved to the Judiciary report. Representative Epps. Representative Epps.
Thank you. Thank you, Madam Chair. In House Judiciary Committee, the thing that we want you to know, members, is that the bill, which was already a great bill, was amended to become an even greater bill, incorporating the feedback from stakeholders across the spectrum of the adversarial process, folks from victims' rights groups, from the defense bar, and we're incredibly pleased that it passed Judiciary unanimous, so of course bipartisan, and we would ask for an aye vote on the Judiciary Committee report.
Thank you. To Representative Soper.
Merci. In talking with Representative Epps, we just had some concerns still further with the bill, and I move Amendment L006 to the Judiciary Committee report and ask that it be properly displayed.
Okay, thank you. L006 has been properly moved and is properly displayed. Representative Sopara.
Merci, Madam Chair. What Amendment 6 does is about 4 things. So the first part of the amendment, which would be like lines 1 through 9, it creates a WebEx presumption. So right now, the judiciary uses WebEx as their platform. It's important that we do have kind of a presumption there that we're not limiting it because it could be Zoom or something in the future. Lines 10 through 15 on the amendment requires an on-screen uniform warning. So this warning must state that any recording of the proceedings without a court order, including any screen capture, photography, or audiovisual recording, is prohibited, so that anyone watching on the web-based platform would see this warning. And then lines 16 to 18 of the amendment talks about more privileged communications. So one concern that was raised in committee was when there was a privileged courtroom communication, there's lots of microphones, kind of like we have here in the House, and then you have cameras around. Well, sometimes the audio may be turned off in the courtroom, but if you have another way to record that audio and visual, that could still pick up privileged communications. So how we deal with that is addressed here. And then 19 through 34, lines 19 to 34 in the amendment talks more about sequestration and a sequestration order, and just puts the guardrails that we wanted to see there, and would ask for a yes vote on the amendment.
Thank you. Further discussion on the judiciary report. Representative Mabry.
Thank you, Madam Chair. It's an honor to serve with you.
And an honor to serve with you.
Members, I urge an aye vote on L006.
Thank you. Is there further discussion on L006 to the judiciary report? Seeing none, the question before us is the adoption of L006. All in favor, please say aye.
Aye.
All opposed? All opposed, no. Okay, the ayes most definitely have it. L006 is adopted. Is there further discussion on the Judiciary Committee report? Seeing no further discussion on the Judiciary Committee report, the question before us is the adoption of the Judiciary Committee report. All in favor, please say aye. Aye. All opposed, no. The Judiciary report is adopted. To the bill, Representative Mabry.
Thank you, Madam Chair. Members, I will be uncharacteristically brief, but the courts have been doing this for 3 years. It has been working. We believe that public observation of judicial proceedings helps ensure fairness, transparency, accountability, and it promotes public debate and discussion about the law. We did extensive stakeholding on this bill, and I believe we passed unanimously out of judiciary. And we urge an aye vote.
Thank you, Representative Soper.
Merci, Madam Chair. I also rise in support of House Bill 1182. I didn't quite remember that it was unanimous in judiciary. But certainly I appreciate being able to have the concerns we raised addressed in the previous amendment that we just adopted. I had been kind of skeptical, to tell you the truth, about having cameras in the courtroom. And my skepticism stemmed from the fact that I didn't want attorneys to really start becoming actors and witnesses to start becoming actors, really playing to that at-home TV audience, and to just have it become Colorado courtroom TV. But as we started talking more and more about the concept, first of all, here in the House chamber and in the Senate chamber, Coloradans can log on to the Colorado Channel from anywhere, and they can watch us doing the work of the people. And when it's a criminal court proceeding that's a very public proceeding, any of us could actually go to the courthouse and sit in the gallery. Much like we have a gallery here, courtrooms also have a gallery where you can watch and observe. And throughout the pandemic, we were able to see how this technology worked. It was kind of a test run. And what we discovered was courts didn't have to invest in very expensive video equipment. It was as simple as the little computer camera, oftentimes placed on the judge's bench. And it allowed people at home to see what was going on. And certainly, it was one thing to basically replicate what you could do in person, remotely. And it was a good experience, but being able to have the safeguards that we've addressed here, such as what happens if something privileged does get picked up? How do we strike that? How do we make sure that witnesses aren't at home listening? And having all those questions answered gives me the reassurances to be able to stand here and tell you that I'm going to be a yes vote on 1182. So you've done great work, and also we're also seeing how 1182 can even play out, seeing as how one of the sponsors is on the screen. So bringing the House floor. Oh, okay. To correct the record, for those millions of people listening at home, it was unanimous in House Judiciary. I think my yes vote had the caveat that we would address some of these things, which you did. So I appreciate that. Thank you.
Thank you. Is there any further discussion on HB 231182? Representative Evans.
Thank you, Madam Chair. Now that we've cleared up the fact that this bill was unanimous out of committee, we can also confirm for the record that I also voted for it to pass favorably out of committee. And I also just wanted to rise to thank the sponsors of this bill. When I first heard the concept, I was definitely intrigued. For me, my analogy was a comparison to how body cameras are used in law enforcement to provide that transparency so that everyone can see what's going on. And I personally loved my body camera because my body camera showed exactly what happened. And so when there was questions about what's happening, what's going on, it provided the transparency so that everybody had that fidelity. And I saw this bill as very much analogous to that same principle. I saw this as providing a situation in which folks who are already allowed to come into a courtroom to observe the proceedings, I saw it as a situation in which they could utilize modern technology to also be able to monitor those proceedings without having to go through all the time and the headache and the hassle of getting in the car, driving down to the courtroom, and participating in person. And to me, this was something that was beneficial on a couple of different levels as long as it took certain things into account. One of my first concerns was small rural communities. This could definitely be of benefit to rural communities that have greater distances to travel in order to get to a courthouse, but I wanted to make sure that this also didn't unduly burden small rural courtrooms that might not have had the resources to be able to have this audiovisual and online equipment. But that was something that the sponsors worked on and took care of. And so I was very happy to see that, very appreciative of the fact that this made some concessions for those small rural communities. It did not impose an unfunded mandate on them. It very generously used the word may, if able to do so, and I was very appreciative of that. And like some of the colleagues that have spoken before, I also had some concerns about attorney-client privilege and confidentiality. I also had some concerns about victim safety and officer safety with this bill. Namely, if there's multiple microphones and multiple cameras that are in a courtroom, is this creating a situation where victims might be discouraged from testifying and testifying honestly because they don't want to broadcast to the entire world some of the most embarrassing and sensitive times in their life? Similarly with law enforcement, if you have law enforcement that's been performing a confidential or sensitive investigation, maybe involving undercover work or something like this, would this bill have sufficient protections in it to ensure that the security of some of that sensitive law enforcement information was protected? And so as this bill evolved and additional concessions were made and the stakeholding process was occurred, I was happy to note that there were definitely provisions included in this bill that would allow the discretion of the judge to ensure that the safety and the confidentiality and honestly the dignity of victims and law enforcement was protected in this bill. And then finally, as my previous colleague had discussed, I just wanted to thank the bill sponsors. I was a tentative yes vote out of committee, contingent on the amendment that we just saw being brought on the floor. Because I also had concerns with those multiple different microphones in the courtroom, that there could potentially be a situation where folks think that all the microphones are off, but maybe it's just the microphone at the desk that's off, but the microphone that's transmitting to online has been left on inadvertently. And so I was glad to see this amendment. Very appreciative of the sponsors for following through on that. And so for all of those reasons, I was able to vote yes on this bill as it passed out of committee. And I will also be a yes vote today because I think it does what it's trying to do. It provides the appropriate safeguards and the appropriate balances so that folks can participate in or can observe courtroom proceedings with the appropriate safeguards in place to protect attorney-client confidentiality, to protect the anonymity of victims, to protect law enforcement sensitive investigations. And so for all of those reasons, like I said, I just wanted to extend my thanks to the sponsors for working through those issues, and I will be a yes vote on this piece of legislation.
Thank you. Is there any further discussion? Representative Luck.
Thank you, Madam Chair. When I first heard about this bill was actually during the interim. I was contacted by a stakeholder who very much desired to see this policy put into place, and it was intriguing to me. I had a couple of conversations about it and did have a few concerns, especially as relates to some age-old problems about having court cases become spectacles and struggles related to that. But as the bill took form, as as the idea got put to paper, I became more and more comfortable with the idea and did have a few concerns in committee, which I'll get to. But here are a few things that I found valuable. So as a former teacher, the idea that we could put on a recording or a live stream of what was going on in our county or in someone else's county and review some of those criminal proceedings was beneficial to me. So often our young people don't really have very much understanding of the civic system, and to be able to experience that in a 4th grade history class or a 6th grade civics class, I thought was a good benefit so that our folks, our kids, can get comfortable with a place, which leads me into the next area of benefit that I saw, which is as law students, future lawyers, were often encouraged to go and to sit in a courtroom. And so here you would again have the opportunity. I often didn't have the opportunity to get to a courtroom based off of my law school schedule. And so I didn't have that benefit of watching very many proceedings. But here you would have a situation where you could watch it over lunch, or you could engage in a break period that you have and see best practices in place. You can actually watch the different parties interact and the ways that they present argument and improve your own skills in doing so. Yes, Madam Chair. Thank you, Madam Chair.
Representative Luck, please proceed. I didn't understand. My mic wasn't on. Thanks.
Thank you, Madam Chair. So in addition to those two teaching elements, there's also the element of benefit that comes to citizens who often want to know who to vote for a judge. I get questions a lot and have for a number of years about who should we vote for a judge, because judges don't have the same sort of website presence or informational presence for people to be able to discern whether they want to retain that judge or not. And with this type of an open court, they can just spend a few moments or hours, however much they would like, watching some proceedings and seeing how judges interact with clients, judges interact with counsel, judges interact with the defendant, and determine for themselves whether they think that that particular justice is a fair justice, or if there's any questions that might lead them not to want to retain that particular judge. Which then goes into the next benefit. It's a much wider benefit, and that's a benefit for those of us who are concerned about the justice system as a whole. How is it operating as a whole? Is it operating well, or is it struggling? If we have the ability to sit and watch multiple court proceedings, not having to drive all over the state to do so, but to be able to watch in the comfort of our house. We have the ability, these organizations especially have the ability to do research, to do data management, to be able to pull information and thereby determine, is the justice system as a whole experiencing certain problems? Or is it not experiencing certain problems? Is there a systemic issue in a particular courthouse or across a particular set of issues? For instance, all the DUIs or all of the robberies, and to be able to pull that and to watch these proceedings and to see how these things are happening, different elements that courts are struggling over and wrestling with in real time, then helps to provide us with the information we need here in the legislature, which I suspect that many of these organizations will begin to compile in order to make any necessary changes. And so those are a few of the benefits that I see. We know, too, that this has to do with remote public viewing, but we also know that there is participation from those impacted and involved in this, and that's a separate issue, but it does have a correlation here, because by developing this technology in all of our courthouses and encouraging it, it just ensures that we are able to facilitate those individuals who would want to participate but might be prohibited because of a disability, because of costs to get to the courthouse, etc. Some of the issues, though, that I did have, the bill sponsors have been kind enough to work with me on, and one of those is the listening in real time, right? So I was first concerned that this would be a system like the Colorado Channel, where the video is captured and then put on a website permanently. And I was concerned about that because I didn't want the decisions of people to haunt them as a defendant. I also didn't want victims to be re-victimized regularly in the event that somebody pulls that video and shares it or shares a link to it. I wanted there to be an assurance, a greater level of assurance that information wasn't just out there on the internet indefinitely. And so the in real time is important to me. Other pieces of the in real time, though, that we grappled with were in that prior amendment, but just the idea that what if somebody does capture this? What if somebody sets up their technology in order to video it or screenshot it so that they can post that on social media, or in the event that they want to harm a particular party involved in the criminal proceeding, send it to employers, send it to future spouses or relationship partners. And so I wanted to see what kind of safeguards could be put. And the fact that the amendment sought to provide greater protections there so that people have to check a box, right? They have to agree to a set of terms that says, recognize you're not allowed to do these things, otherwise you will face a penalty, above and beyond the penalty that you may incur just under harassment charges or other such things, was an important addition. It's also important that these individuals know that there is a degree of privacy. And so in talking to the bill sponsor, who has seen a variety of these court proceedings, it was told to me that many times the cameras aren't actually focused directly on the witness stand. They're not actually focused in a way that you can make out the person who is speaking. And so in some ways it's an audio recording more so in many of these courts than a visual one. And that, I understand, help victims' rights groups to say, we feel more comfortable with this, knowing that these cameras can be turned away from the victim so that we're not showing their face, or they are back towards the back of the courtroom so that they can they're not straight front and center. The person who is speaking provides a degree of privacy. please note that these live streams of these proceedings only apply when the court has opened the courtroom to the public. So if you can go in person and you can sit in the courtroom, you can watch it from the comfort of your house. If the judge determines that it is not appropriate to have the public in the courtroom for whatever reason that may be, then the virtual is also turned off. The live stream is also turned off. So for those who are concerned about whether the judge has any discretion as to whether they can put this recording on or off, please be assured that the judge does maintain their discretion, and they are able to make sure that all of the parties are protected, though the presumption is that those cameras will be on every time, providing us in the public the opportunity to watch, our kids to learn, our law students to learn, those who might want to be holding the judiciary accountable and responsible, or research what's going on in our judicial department, those also are benefited greatly by this policy, and therefore I thank the bill sponsors for bringing it.
Thank you. Is there any further discussion on HB 23-1182? Representative Epps.
Thank you, Madam Chair, and thank you, colleagues. As our colleague mentioned, it seems fitting that while I wish I could be there in person, it certainly is a nice, appropriate irony that I'm able to participate remotely, because Colorado has done such an excellent job in the past 3 years, and even reaching back further to advance the goals that are quite shared with 1182. While we don't name organizations by name in our remarks at the well, I just want to note how important it is, and how honored we are as sponsors and as folks who work on 1182 to recognize that not just was this bipartisan, but this bill and the work to get a really good bill to send to our colleagues in the Senate is one that brought together very disparate groups in terms of freedom of information advocates, press folks, our friends in more conservative circles, and a particular thanks to our friends in the disability justice community who really amplified for us how much this technology has been abused. For all of those reasons, with deep appreciation for the stakeholding and the support of our community and our colleagues, we ask for a yes vote on 1182.
Thank you. Is there any further discussion on HB 23-1182? Seeing none, the question before us is the passage of HB 23-1182. All in favor, please say aye.
Aye.
All opposed, please say no. The ayes do have it. HB 23-1182 is adopted. Mr. Schiebel, can you, Madam Majority Leader.
Thank you, Madam Chair. I'd like to move House Bill 1245. I'd like to lay over House Bill 1245 until tomorrow.
Okay, HB 23-1245 will be laid over till tomorrow. Madam Majority Leader.
Madam Chair, I would like to move House Bill 1102 to the end of the special orders calendar today.
Okay, HB 23-1102 will be moved to the end of the special orders calendar. Thank you. Okay, Mr. Schiebel, please read the title of HB 23-1276.
House Bill 1276 by Representatives Lindstedt and Vigil, also Senator Zenzinger, concerning the bridge and tunnel enterprise and in connection therewith, expanding the scope of the enterprise's powers to include the completion of prevention maintenance bridge projects and allowing the enterprise to repair, reconstruct, replace, and maintain a fair-rated bridge under certain circumstances.
Thank you. Representative Lindstedt.
Thank you, Madam Chair. I move House Bill 1276.
Thank you. There are no committee reports, so to the bill.
Thank you, Madam Chair. This bill is pretty simple. Currently in statute, the bridge and tunnel enterprise is only allowed to repair, reconstruct, and replace bridges that have received a poor rating, and House Bill 1276 enables them to provide preventative maintenance on good and fair rated bridges, and also the replacement of fair rated bridges when they bundle the project with a poor rated bridge project. This bill will save taxpayers money, reduce the impacts to the traveling public on traffic, and increase safety for workers who are doing these projects. I'll just close by saying that there are bridges in all corners of the state, and help us bridge the urban-rural divide by passing this bill.
Thank you. Is there any further discussion on HB 23-1276? Seeing none, the question before, Representative Taggart. Members, if you wish to speak, you need to be in the well prior to the previous speaker ending. We're not going to be doing this. So Representative Taggart will allow it this time.
I'm sorry, Madam Chair. I just want to also support this bill very much. From somebody that comes from business and is always very concerned about efficiency, the ability of CDOT to work on a bridge that's in fair condition when they're doing other work around it just makes a great deal of sense to me, because it's already deteriorated to a certain point, and not to tackle it right then and there, as compared in the past to waiting till it gets to be poor condition and then doing it, and having it separate from the roadway that might be worked on at that particular time just has never made sense to me. And this will really help us in rural and western Colorado. So I thank the sponsors for bringing this forward. Thank you.
Thank you. And I see one of our sponsors is online, Representative Ehill. Representative Ehill.
Thank you, Madam Chair. I just want to thank my fellow Prime sponsor. Oh, wow. Am I echoing? Okay. If we're good, I'll proceed. I just wanted to reiterate, this is a really great way to save the taxpayers money on preventative projects. And also just to remind members, this is the bridge and tunnel enterprise. So it is also sanctioned to tunnel the urban-rural divide. And I ask for your yes vote.
Thank you. Representative Frizzell.
Thank you, Madam Chair. Hi. I would just like to speak in favor of work on our state infrastructure. It is in desperate need of updating, fixing, replacing. I know that there are some overpass bridges in my hometown of Castle Rock that sometimes I have to think twice about actually driving over, and they are state bridges. So this is really an important part of keeping our society civilized. Transportation infrastructure makes sure that we can get where we want to, when we want to, and how we want to. It's a critical component of this country, this state, and our communities. Because if we don't have dependable infrastructure, we're kind of sunk. So I stand in support of this bill and thank the bill sponsors for bringing it forward.
Representative Winter, I believe, had his hand up next.
Thank you, Madam Chair. Thank you to the bill sponsors. I know that part of this issue arose from a county in my district, if I'm pretty correct. Was it Huerfano County?
Most of our districts.
Well, thank you. This is a good bill. It's good for rural Colorado. I know that, if we're mitigating, working on one side of the road while we're in the area and we have a bridge in disrepair, it would only make sense to take our resources, move them across the road, make the dollars go a little bit farther. So I rise in support of this. Thank you very much for bringing this. It's good for all of Colorado, but especially good for rural Colorado, where we're left out of the conversation a lot of the time, especially when you see how our roads look. So thank you.
Thank you, Representative Holtorf.
Thank you, Madam Chair. And I do want to also thank the bill sponsors. In rural eastern Colorado, we've got a lot of problems with roads. We're underinvested. I get calls every week about the roads from constituents. I just got a call today this morning on roads and bridges and the deterioration of our rural roads. So, and bridges too. And we've got some serious accidents just east of my hometown. We have a bridge that's caused more accidents and incidents than any other location on Highway 34 between Akron, Colorado and Yuma, Colorado. And so this bill right here points right to that. So thank you. Thank you to the bill sponsors for that. I want to vote yes on this one.
Representative Soper.
Merci, Madam Chair. I also wanted to come down and express my support for this bill. One thing that's about to happen that this bill will also consider is the Floyd Hill project that CDOT is going to be starting. So that's a bridge on I-70 as you're going up into the mountains. And this is going to be a major project because we're now going to have stacked bridges that are going to go through I-70. It's going to be a major, major project. But that comes from not only deteriorating bridge conditions, but also the need to undo a bottleneck. We celebrated the 50th anniversary of the Eisenhower Tunnel this year. 50 years. Our tunnels need constant maintenance, constant repairs, as do our bridges. And it's time that we don't ignore them. And the good work of the enterprise has been able to do that. That CDOT has identified that, like, over the next 10 years, there's $522 million of tunnel and bridge projects that are scheduled. So this is good work. Thank you very much.
Thank you. Is there any further discussion on HB? Representative Luck.
Thank you, Madam Chair. So, I agree. My dad was a mechanic, and he was always about the maintenance, always about the maintenance. You save a lot of money when you do maintenance. But I'm just wondering, I noticed that there is no fiscal note to this, that it's going to be able to be done, at least right now. But then on the fiscal note, it says that there may be additional costs in the near future or near term. And I'm just wondering, your conversations with CDOT, did they flesh out how they're going to prioritize and how much they're going to be able to get done and how likely they are, as a result of this, to be requesting future dollars in, let's say, the next 5 years or so for this?
Representative Lindstedt.
Thank you, Madam Chair. Yes, there will be maybe an increase in immediate maintenance because we allow them to provide maintenance on bridges immediately by repealing these rules. Thank you.
Thank you. Is there any further discussion? Representative Luck.
Thank you, Madam Chair, and thank you for that answer. I'm just trying to understand. Just making sure that the resources won't be. They're not concerned in any way that they're going to be stretched thin, and then also just trying to make sure that I understood what the prioritization would be. But I completely support the idea of maintaining as opposed to having to come in when it's the London Bridge, which, by the way, somebody actually bought and thinking it was Tower Bridge and had it mailed to Arizona, and were very disappointed when it was not the bridge they thought they bought. Thank you.
Thank you. Is there any further discussion on HB 23-1276? Seeing none, the question before us is the passage of HB 23-1276. All in favor, please say aye. All opposed, no. The ayes have it. HB 23-1276 is adopted. Mr. Schiebel, can you please read the title of HB 23-1261?
House Bill 1261 by Representatives McLaughlin and Martinez concerning removing the requirement for a student to register for the United States Selective Service System to enroll in a state-supported institution of higher education.
Thank you, Representative McLaughlin.
Yes, I move, there we go. I move House Bill 1261 on second reading, please.
Would you mind moving the committee report as well?
And we'd like to do the committee report, please.
Okay, thank you. To the committee report, who would like to speak to the committee report? Representative Martinez.
Thank you, Madam Chair. So on this committee report, we added one amendment on, and so right now this is a federal mandate that had happened, that they removed the federal requirement for selective service from Pell applications, and so this is really following in suit. However, we're taking it one step further, and we are saying that the institutions of higher education will provide that selective service information to the prospective student, and we request an aye vote.
Thank you. Is there any further discussion on the education report? Seeing none, the question before us is the adoption of the education report to HB 23-1261. All in favor, please say aye.
Aye.
All opposed, no. The committee report passes. To the bill, Representative McLaughlin.
Thank you, Madam Chair. Yes, in 2022, the federal government decided to narrow down the FAFSA applications, free application for student financial assistance, which was really a large application. So they cut it down, and in that they cut out the requirement that students apply for selective service on that. Colleges depended on FAFSA to see if a student coming into college was a part of that. And now that nobody has to report that, it's going to be a whole lot more work for our schools of higher education. So this just matches what the federal government is doing, and like, you do not have to report this. They have other ways of encouraging students to apply, but it's not a requirement for college after this bill.
Thank you. Further discussion on HB 23-1261. Seeing none, the question before us is the passage of HB 23-1261. All in favor, please say aye.
Aye.
All opposed, please say no. The ayes have it. The HB 23-1261 is adopted. Mr. Schiebel, can you please read the title of HB 23-1262?
House Bill 1262 by Representative Ricks, also Senator Priola, concerning allowing a student to receive an associate degree from the Colorado Reengage Initiative after earning a certain number of credit hours from a different institution.
Thank you. Representative Ricks.
Thank you, Madam Chair. I move House Bill 1262 and the committee report.
Okay, can you move 23-1262?
Okay, I move House Bill 1262.
Okay, and there is no committee report. So to the bill, Representative Ricks.
Back in 2021, me and Speaker McCloskey created what we call the Colorado Reengage Initiative through House Bill 1330. CORE enables four-year institutions in Colorado to award an earned associate degree to eligible students who have stopped out from earning a baccalaureate program after earning at least 70 credit hours. The COVID-19 pandemic forced many students, particularly those in low-income communities, to stop attending the state colleges and universities before attaining a bachelor's degree. This is a technical fix to 21-1330, and this will make it simple to allow students who earn at least 15 credit hours at a community college prior to transferring to a four-year degree to be eligible for the CORE initiative. If they meet all the other CORE eligibility requirements, we estimate that there's about 6,300 students here in Colorado that will be able to take advantage of this. We also understand that it's very important that people in the 21st century have some type of credential or certification in order to be able to achieve a high-paying job. We ask for your aye vote.
Thank you. Representative Bradley.
Thank you, Madam Chair. During the bill being read, there was some questions about if there was an impact to community colleges. There's not. They don't offer an associate's degree. All it's doing is if someone is at a four-year college and they completed 2.5 years but had to leave because of health problems or an emergency or COVID pandemic, they can be awarded an associate's degree from a four-year college. We didn't have any opposition to this bill. In fact, we had plenty of four-year institutions like CSU Fort Collins, Pueblo, Fort Lewis College, Metropolitan State, UC Denver, UC Colorado Springs, and University of Northern Colorado, all in favor of this bill. Like I said, it just, for people that don't finish their four-year degree, they don't lose all the time, energy, and money that they used to go for as long as they did. So we urge an aye vote on this bill.
Thank you. Is there any further discussion on HB 23-1262? Seeing none, the question before us is the passage of HB 23-1262. All in favor, please say aye. All opposed, no. Okay, the ayes have it. HB 23-1262 is adopted. Mr. Schiebel, can you please read the title of HB 23-1263?
House Bill 1263 by Representatives Garcia and Young, also Senators Zenzinger and Gonzalez, concerning translating individualized education programs for children who may be eligible for special education services.
Thank you. Representative Young.
I move House Bill 23-1263.
Excellent. Would you like to tell us about your bill? Representative Garcia. Representative Young.
I have been committed to parent participation as an educator, first as a special education teacher and school psychologist since I've worked in Colorado. It is important to include everyone in the process, and parents are essential to that process. In our schools now, it is wonderful to see we engage parents early on when their children and youth are encountering learning problems, and it is so essential that we are able to include parents whose English is not their dominant language. And part of that process is at times the team comes together and decides a special education evaluation is needed and potential IEP developed. And as of now, parents whose English is not their dominant language is not presented with that draft IEP a few weeks beforehand. And their information is critical to this process. As parents, they know their child, as we've said many times in the well, they know their children better than anyone. So we need to include them in this process. There are critical questions that they need to know that they're going to be asked in this process, such as, does the fact that they're a second language learner impact a decision about eligibility, or are there cultural factors that need to be considered? So this is a very important bill. I urge and I vote.
Thank you. Representative Garcia.
Members, I am really honored to bring this bill forward. This is a bill that I know several organizations have been working towards for many, many years, and to be able to bring this forward with my co-prime, Representative Young, is really exciting for me. I want to highlight just a couple of things here is that the reason why it's essential that families have access to the information of an individual learning plan, the IEPs, throughout the process is because if you have not participated in developing the IEP, then you don't understand that what you're getting is you're getting multiple drafts of what an IEP looks like, and each draft can be anywhere from 8 pages to 40 pages. And these drafts have information about your child. They have information about different learning options. They have information about diagnoses, disabilities. They have information about interventions. And if you can't read those drafts, then how can you as a parent effectively help develop the final IEP plan? So this bill is pretty simple, as in it creates a new section in our statutes that says that school districts with appropriate resources are in fact able to and should, if they can, translate draft IEPs. And we have one amendment that we're bringing forward. So do I do that now? Yeah. Okay. So I move L002 to House Bill 23-1263 and ask that it be displayed.
Thank you. Whoops, not quite.
Is anybody behind my back? How many?
Okay, wonderful. L002 has been moved and is properly displayed. Please tell us about your amendment. Representative Garcia.
Thank you, Madam Chair. So the first part of this amendment, lines 1 through 5, is really just a clarification. It's not changing anything or adding anything that isn't already required when communicating with parents and students. It just reinforces and adds another section that any sort of communication in a public space, in an education system, has to be done so under the federal regulations of Americans with Disabilities Act. Lines 6 and 7 just clarify that this is not in fact the IEP team that has to do the translation, but that it's the IEP team that has to provide the translation. So they can do that either through, if there's in-house staff to do it, or they can do it through contracting with a translation service provider to translate. And the same goes for lines 8 and 9. And this was in response to just to clarify some language that a school district needed for themselves.
Thank you. Is there any further discussion on L002? Is this to the amendment, Representative Bottoms? Okay, Representative Bottoms.
So thank you to the bill sponsor. Thank you, Madam Chair. Thank you to the bill sponsors. Again, this is a good bill. The part I was concerned with is what you just said on the amendment. So this is good because I do think the way that it was originally worded gave potential for it to get too big and outside the scope of the ability of individual groups to accomplish the task of the bill. If you're talking 2 or 3 languages, no problem, but specifically Denver, specifically Colorado Springs, we've got so many languages, and there's going to be kids wanting school, needing school. They're going to fall into this. So, I actually can't believe I'm saying this out loud, but I do urge an aye vote on this amendment, and because it fixed the problems that you guys didn't fix earlier, and so that's enough of a dig to make me feel good. So I urge an aye vote on this amendment, and with this amendment, I can actually vote for the bill too.
Excellent, thank you. Representative Holtorf, is this to the amendment? Representative Holtorf, are your comments to the amendment?
Yes, ma'am.
Okay, then go for it.
So with respect to translation in eastern Colorado, we have a growing Hispanic population, and particularly with special needs, as the school population grows in this demographic. Madam Chair, this amendment helps so those kids, particularly their parents who may not be fluent in English, can have and can get this information. So absolutely, this is a good amendment. Oftentimes, a lot of times BOCES and those agencies work with a lot of the special needs out there in my district. And I've actually done translation services myself in Washington County, the Washington County court system, as a volunteer. And I know the importance of this, particularly when you have people that aren't fluent, and there's very important things that are going on, and they don't understand. And so I rise in support of the amendment. And if you want to know, Madam Chair, my support of the bill, I'll come back and tell you.
Thank you. Is there further discussion on L002? Seeing none, the question before us is the adoption of L002 to HB 23-1263. All in favor, please say aye. Aye. All opposed, no. The ayes have it. HB 11002 is adopted. Further comments on HB? Oh, I'm sorry, on 1263. L002 to 1263 is adopted. So are there further comments on the bill? Any further discussion, Representative Holtorf?
Madam Chair, since you asked.
I didn't ask. I
Oh,
didn't
you didn't ask? I could have swore I heard your sweet voice, ma'am. I'm in support of this bill, Madam Chair, just for the record.
Thank you for clarifying. We appreciate it. Representative Wilson.
Thank you, Madam Chair. I also come in support of this bill. I was concerned at first that this would be a new expense and a new responsibility on schools, but as I learned from the sponsors in our discussion and through the bill, that this already takes place. It just only takes place in the final version, not the drafted version, and we want our parents to be engaged in the process from the beginning, not just in the final draft. The other concern of mine was funding, and this bill provides funding to the school districts so they're not, if there's any excessive expense on this, for this program, the schools have a way to get some funding to support that. So with that, I also ask for an aye vote on this bill.
Thank you. Is there any further discussion on HB 23-1263? Representative Luck.
Thank you, Madam Chair. So, I too rise in support of this. As a prior teacher, I can tell you that when parents get involved, kids do so much better. I had a number of kids, in fact, more than half of my students came into our school at at a level well below grade level. We're talking 2 or 3 grade levels below the grade level that I taught. And when the parents got engaged, when the parents got involved, when they understood the expectations that I was setting in the classroom and understood the tools available to them and the ways that their children were learning or struggling in different areas, and they got involved, those kids began to just soar. And all of them, I'm proud to say, ended the school year in certain subject matters at or above the level that we were at. And I attribute a large part of that to parental involvement. And so the fact that this bill just continues to enhance parental involvement, says to our parents, we want you to be a part of this process. We know that you know your kid well beyond anyone else in this world, and you have the desire to be invested well beyond anyone else in this world. And so we want you to be part of this discussion about what will make them successful is essential. And so I appreciate that it's not just a baked cake for them, right? Here's the final, and this is what's going to be. And they don't have really the ability to process, read, understand, and make their own contributions to that, so that the final product is something that is something they can stand behind. I appreciate the heart and the motivation behind this, and so I too will support it. Thanks.
Representative DeGraff.
Thank you, Madam Chair. Okay, 22-1-130A1A1. It is the right and responsibility of parents to guide the education and upbringing of their children. 13-22-107-1A. Parents have the fundamental right, responsibility to make decisions concerning the care and custody of and control of their children. So what I see is this puts responsibility back in there, and that this would fall under the just powers of securing the just powers of securing the life, liberty, and pursuit of happiness of our constituents. So I'm pretty happy about that. Thank you.
Wonderful. Thank you so much. Is there any further discussion on HB 23-1263? All in favor, please say aye. Aye. All opposed, no. Okay. HB 23-1263 is adopted. Mr. Schiebel, can you please read us the title of HB 23-1275?
House Bill 1275 by Representative Lindstedt, also Senator Roberts, concerning modifications to the performance-based incentive for film production in Colorado and in connection therewith, clarifying the definition of qualified local expenditure for payments to personal service corporations, requiring production companies to file information income tax returns regarding such payments, and eliminating the withholding exemption for payments to non-residents who perform services in connection with a film production for less than 120 days in a year.
Thank you. Representative Lindstedt.
I move House Bill 1275 and the Finance Committee report.
Excellent. To the Finance Committee report.
In the Finance Committee, we took one amendment from the Department of Revenue to make sure that this change was prospective starting in next year. So that's it.
Okay. Further discussion. Representative DeGraff.
On the Finance Committee report.
No.
Oh, not to the committee report. Well, we'll wait a moment then. So is there any further discussion to the committee report for HB 23-1275? Seeing none, the question before us is the adoption of the Finance Committee report to HB 23-1275. All in favor, please say aye.
Aye.
All opposed, no. The aye definitely has it. HB 20, so to the bill.
Thank you, Madam Chair. This is a pretty simple bill. It modifies the film incentive production program to pay personal services corporations and provide a mechanism within the Department of Revenue to collect taxes. So pretty simple. The bill title is very narrowly defined to this problem within the film incentive program. So I think we can all agree, regardless of what we feel on the film incentive program, that it should work. So I urge an aye vote. Thank you.
Thank you. Representative DeGraff.
Hey, Madam Chair. I'm all for incentivizing and all for having the film industry out here. I'm afraid this doesn't address the underlying conditions, although from talking to the bill sponsors, I do understand that some of the communities have a leg up on us based on their governments are doing what I would consider is outside the scope of government. Still, I think it's a great boon. I would rather see this handled on the the civil side, on the individual citizen side, the citizens, there are definitely industries that would benefit, and based on the analysis and what we're told about this, the industries that would benefit greatly, and so it would seem more appropriate to go to them and or encourage them to incentivize a film industry to come here where they're going to reap the benefits, as opposed to getting the government involved outside the scope of things that we should be doing. So that's my concern. I'm all for encouraging the film. I just think it should be done in the private sector and not public.
Wonderful. Is there any further discussion on HB 23-1275? Seeing none, the question before us is the adoption of HB 23-1275 as amended. All in favor, please say aye. All opposed, no. HB 23-1275 is adopted as amended. Mr. Schiebel, can you please read us the title of HB 23-1250?
House Bill 1250 by Representative Puglisi, also Senator Pelton B, concerning a correction to the Colorado Revised Statutes to ensure that the Attorney General's powers and duties include concurrent jurisdiction with the relevant district attorney over the regulation of architects.
Thank you. Representative Puglisi.
Thank you, Madam Chair. I'm on the Statutory Revision Committee. This is a typo in statute. Title III affects land surveyors. Title IV affects architects. We are just changing Title III to Title IV. There's a petition clause in case anybody wants to petition the correction. Thank you.
Thank you. Representative Puglisi, could you please move the bill? 1250.
Thank you, Madam Chair. I move 1250 for adoption.
Yes, thank you. So is there any further discussion on HB 23-1250? Representative Zleck.
Yes, thank you, Madam Chair. So we heard this bill in committee, and I'm just wondering from the bill sponsor, since we're striking the AG's authority to, in this section, to regulate land surveyors, can they regulate or have oversight over land surveyors and other part of the code? Do you know?
Representative Puglisi.
Thank you, Madam Chair, and thank you, Representative Luck, for the question. Yes, they do have authority over land surveyors. It is in another section. I don't have that with me, but I can get that to you. But it is not in Title III for architects. Thank you.
Is there any further discussion on HB 23-1250? Seeing none, the question before us is the adoption of HB 23-1250. All in favor, please say aye. All in favor, please say aye. Okay. All opposed? No. Okay, that's better. The ayes definitely have it. HB 23-1250 is adopted. Okay. Mr. Schiebel, can you please read the title of HB 23-1280?
House Bill 1280 by Representatives Joseph and Soper, also Senators Roberts and Gardner, concerning the codification of the Colorado Access to Justice Commission.
Thank you. Representative Joseph.
Thank you, Madam Chair. It is an honor to serve with you.
And an honor to serve with you.
I would like to move House Bill 1280 and the House Judiciary Report.
The Judiciary Committee report?
Thank you, Madam Chair.
To the Judiciary Committee report. Is that the one that you moved? Can you please move it?
Yes,
okay.
I did.
Would you like to speak on
Okay.
Yeah. No.
the committee report?
To the Judiciary Committee report, who would like to discuss it? Representative Soper.
Merci, Madam Chair. So in the House Judiciary, we struck out some language that would have required the President of the Senate, the Speaker of the House, and the Governor to coordinate on their 3 appointments to the Commission. That was seen as a challenge, and they would rather just go ahead and appoint who they're going to appoint without having to try to coordinate, because no one else is trying to coordinate on appointments on the Commission.
Thank you. Is there any further discussion on the Judiciary report? Seeing none, the question before us is the adoption of the Judiciary report to HB 23-1280. All in favor of the Judiciary report, please say aye.
Aye.
All opposed, please say no. The ayes have it. The Judiciary report to HB 23-1280 passes. To the bill. Representative Joseph.
Thank you, Madam Chair. The bill extends the authority and duty of the Colorado Access to Justice Commission, which is currently a nonprofit, and this bill would just ensure the codification of the nonprofit, and I don't know if my co-prime Rep. Soper would like to add anything further. Thank you, Madam Chair.
Thank you. Representative Soper.
Merci, Madam Chair. So the Colorado Access to Justice Commission is currently in its 20th year, being started in 2003. And what the commission helps facilitate is when you have these civil legal aid clinics that are operating around the state to be able to help advertise those, help the local bar be able to work with Coloradans, particularly on issues that can be major life-altering issues, to be able to have an attorney sit down with an individual much earlier rather than later. Things like divorce or custody, eviction, protection orders, public benefits, veterans issues, healthcare issues, and other legal problems that upend individuals' lives. And it's been very successful. But what we're wanting to do in this bill is to actually incorporate it into state law, give them the ability for a line item in the future. But more importantly, it will require that the commission reports to the General Assembly every year, rather than just having them come when we invite them. They will actually have to come and talk to us every single year, so there's accountability. But housing it in judiciary also means that we're saying as a state, this is valuable enough that we want this to last from here on out, because sometimes the fear of having a organization out there that's doing good work is you get people who die and their place on the board's not replaced, and before long it becomes defunct and no longer operational. So making this part of the state means that it will go ahead and last and continue to serve Coloradans for many, many years into the future and be a valuable tool, and would ask for a yes vote.
Thank you. So that was the judiciary report, correct?
That was to the bill,
Okay.
Madam Chair.
Okay, well, I don't think we've adopted the judiciary report yet, so let us let us adopt the judiciary report. Is there any further discussion on the judiciary report? Seeing none, the question before us is the adoption of the judiciary report to HB 23-1280. All in favor, please say aye.
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 All opposed, please say no. The judiciary report to HB 23-1280 is adopted. And now to the bill, if you have additional comments, Representative Joseph.
Thank you, Madam Chair. We've already made all the comments about the bill. We're just actually asking the body to please vote yes. Thank
Okay,
you.
is there any
Aye.
further discussion on HB 23-1280? Representative Luck.
Thank you, Madam Chair. So yesterday in committee when we heard this bill, that was just yesterday, yes? Okay, just checking. So yesterday in committee, I did have a question about the creation of these two elements. So you have the statutory creation, and then they can maintain the nonprofit under them as sort of a foundation or to be able to do other things. I'm just wondering, do you all think that it's sufficient, the language in here, to ensure that the legislature is seen as the overseen entity over both of those things as opposed to just the statutory creation? Or is there going to be an instance where this subsidiary can somehow operate outside of the boundaries that we have established in this bill?
Representative Soper.
Merci, Madam Chair. And thank you, Representative Luck. That's a great question. So the way the bill's worded, I realized why there might be some confusion from members. Think of it this way. We can have a public hospital, a special district hospital, so it's a government hospital, but then you can have a private foundation, which is the 501c3 typically, and that's the fundraising arm outside of the government entity, and that's what is being created here, so that's the same thing. Where there is going to be a change, and we talked to the Access to Justice Commission, is that having the name be exactly the same for both is super confusing, and it was actually confusing, we found out, to the fiscal analyst, who actually didn't realize that one was really the foundation and one was really the commission, and that those were actually two different entities. And so we've asked the Access to Justice Commission to make sure that the foundation is not also called the Access to Justice Commission, that they need to have a separate name, because the fact that the analyst was confused, we're confused, I guarantee you others will be confused, and they pledged to make that name change.
Thank you. Representative Joseph.
Thank you, Madam Chair. I just wanted to add that this is not the only body that will be able to do this, actually. The District Attorney's Council also have a similar structure, and so does the History Colorado also have a similar entity as part of it as well. So these bodies have been in existence, and we are just borrowing from those models. Thank you.
Thank you. Representative Luck.
Thank you for those answers. So with those other models, does the legislature have access to the financial reports of those foundations? Because it was discussed in committee that the hope is in future years, if not even this next fiscal year, that the commission will ask for general funds in order to support it. Do we have any? Will the legislature be able to look at the books of the foundation as well so that they can make knowing determinations before they give any general fund money into that?
Representative Joseph.
Thank you, Madam Chair, and thank you, Rep. Luck, for this question. The answer is yes.
Okay.
Thank you.
Is there any further discussion on HB 23-1280? Seeing none, the question before us is the passage of HB 23-1280 as amended. All in favor, please say aye. All opposed, no. The ayes have it. HB 23-1280 is adopted as amended. Okay, Mr. Shebel, can you please read the title of HB 23-1268?
House Bill 1268 by Representatives Lukens and Evans, also Senators Robertson, Pelton B, concerning changes to the process for a person serving a criminal sentence in Colorado for a conviction in another state to participate in a private treatment program.
Thank you, Representative Evans.
Thank you, Madam Chair. I move the Public and Behavioral Health and Human Services Committee report to HB 1268 and ask for a favorable recommendation.
Thank you. Can you just go ahead and move the bill at the same time?
And I move House Bill 23-1268.
Thank you. Let's go ahead and discuss the committee report now. Who would like to tell us about it? Representative Evans.
Thank you, Madam Chair. So in committee, we had one amendment to this bill. What the bill generally does is it deals with the interstate compact transfer of folks who are on supervision. You have folks that can be coming into Colorado under this compact, and there's a process by which they can receive treatment in Colorado. What the committee report does is the amendment just says that if somebody is transferring out of Colorado, that it should be a two-way street. So if somebody transfers into Colorado, we follow the Colorado processes and procedures in order to ensure that that person receives the appropriate supervision. But if we transfer them out, then we're legitimately transferring them out, and they are now subject to the jurisdiction of whatever the state that they are transferring to is. And so this just ensures that we have a two-way street, and we're not setting up a bottleneck where folks are coming into Colorado, having to get all of these services, but the process for them to transfer out is not equally streamlined, which would then result in an undue burden in Colorado. So that's what the committee report does, and we would ask for your aye vote.
Thank you. Is there any further discussion on the Public and Behavioral Health and Human Services Committee report? Seeing none, the question before us is the committee report to HB 23-1268. All in favor, please say aye.
Aye.
All opposed, no. The ayes have it. The committee report for Public and Behavioral Health and Human Services report to HB 23-1268 is adopted. To the bill, Representative Lukens.
Thank you, Madam Chair. Today we bring before you House Bill 23-1268, Private Treatment for Out-of-State Defendants. This bill aims to remove barriers to substance use care and clearly define legal requirements to help more individuals access life-saving treatment and protect public safety. This bill will lead to increased public safety as treatment providers are able to, 1, initiate care immediately, and 2, help keep the person engaged and, if warranted, tracked by the appropriate entity. Therefore, we will be asking for a yes vote on House Bill 23-1268.
Thank you. Representative Evans.
Thank you, Madam Chair. As my co-prime so eloquently laid out, what this bill does is it says that if somebody is transferring into Colorado under the currently existing interstate compact agreement, and they are subject to some sort of supervision. Maybe they're on parole or probation for a misdemeanor DUI that they got in Nebraska. When they come into Colorado, and as part of that parole or probation, they're required to seek like alcohol addiction treatment. Under current law, they would not be allowed to begin receiving treatment until they'd first had a background check, fingerprints and photographs taken by local law enforcement and the Department of Corrections. That can take months. So what this bill does is it says that when somebody lawfully transfers their supervised status into Colorado, they can get treatment while they are waiting for that background check to process. It reduces barriers to behavioral and mental health, and I would ask for your aye vote.
Thank you. Representative Holtorf.
So I heard this in public health. It got out of public health unanimously. The program that this bill promotes is very important. The interstate compact arrangements are we're trying to build in almost every space, behavioral health, mental health, physical health, and even with respect to these court-ordered treatments. So we definitely are in support of this House Bill 23-1268 and do encourage an aye vote. Thank you.
Thank you. Is there any further discussion on HB 23-1268? Seeing none, the question before us is the adoption of HB 23-1268. All in favor, please say aye. Aye. All opposed, no. Okay, the ayes definitely have it. HB 23-1268 is adopted. Madam Majority Leader.
Thank you, Madam Chair. I'd like to lay over House Bill 1162 until tomorrow.
Okay, HB 23-1162 will be laid over until tomorrow. That brings us to HB 23-1259. Mr. Shebel, would you like to read the title of HB 23-1259?
House Bill 1259 by Representatives Doherty and Evans concerning provisions in the open meetings law for an executive session of a local public body and in connection therewith, creating a local public body's right to cure a violation of the open meetings law for an executive session, adding prerequisites for a person to challenge a violation by a local public body of the open meetings law for an executive session, and permitting a local public body to recover costs and attorney fees in an action for a violation by a local public body of the executive session provisions if the prerequisites are not met or if the local public body has cured the violation.
Thank you. Representative Evans.
Thank you, Madam Chair. I move House Bill 23-1259 and the committee report.
Okay, the State Civic, Military, and Veterans Affairs Committee report. Would you like to tell us about that? Thank you.
Yes, please. So what House Bill 23-1259 does is it tries to strike a balance between frivolous lawsuits against local governing bodies, but also trying to preserve and protect transparency. So while we're working on threading that needle, what the committee report does is it just lays out in a little bit more clarity that a local government, so like local municipality, school board, something like that, has a right to cure a technical violation to an executive session meeting. And so what we're trying to do, like I said, is ensure that we have that transparency for citizens, but we also are ensuring that local governments aren't being subject to numerous lawsuits for just mere technical violations that could be resolved by actually having a sit-down and a conference with whoever is pointing out that violation. So that is part of the committee report, and then we also have an amendment to the committee report to address a issue that was raised. So with that, I move L003 to the State Civic, Military, and Veterans Affairs Committee report and ask that it be displayed.
Thank you. L003 has been moved and properly displayed. Representative Evans, can you tell us about your amendment?
Thank you, Madam Chair. So this amendment came through some stakeholdering work with like the Trial Lawyers Association, the press, a lot of other different individuals who just wanted to make sure that we were having a level and balanced playing field to ensure that transparency existed, but that we were also making sure that folks had standing in the event that there was a potential violation of this. So what this amendment does is it strikes out the second half of the committee report, which there was some concerns about, just giving the ability of folks to have some standing to be able to bring these suits. And it leaves the first part of the committee report in there, which focuses more on the mediation. Additionally, it strikes out another part of the bill, again, also that deals with standing. Again, we want to make sure that we are not having a bar to people having standing to bring these violations. We just want to make sure that we're resolving them through mediation and curing when possible. So I would ask for your aye vote on L003.
Thank you. Is there further discussion on L003? Seeing none, the question before us is the adoption. Oh, Representative Wilson.
Thank you, Madam Chair. I would just ask the bill sponsor to clarify this amendment a little more.
Representative Evans.
All right, thank you for that question. So, like I said, the amendment does two things. The first part of it strikes lines 9 through 21 in the State Civic Veterans Affairs, Military and Veterans Affairs Committee report. So if you pull out your green sheet there, that's the part where it talks about curing an alleged violation is a bar to any action against a local public body. So we had concerns that that hard bar might be a deterrent, and so we wanted to address that. We also had some concerns as we went down that amendment that talks about the court's decision on this being a final judgment. Again, we just wanted to make sure that folks had the ability to come and bring their concerns to the court and that we weren't creating a hard bar to any of these actions.
Thank you. Representative Wilson.
Thank you, Madam Chair. So this sounds like it takes away the protections you had in there for local body and removing that it keeps any action against the local public body concerning the same allegation, violation, etc.
Representative Evans.
No, so we still have some of those protections in there. There's an additional amendment that I will be bringing to the bill that works to accomplish that same protection again in trying to reduce the frivolous lawsuits, but it accomplishes it through another method. And then you still have in the bill itself the requirement that folks meet and confer in order to make sure that they can sort these things out before they proceed on to any sort of litigation.
Thank you. Representative Woodrow.
Thank you, Madam Chair. It's an honor to serve with you.
And an honor to serve with you.
Thank you. Members, I just want to thank the bill sponsors for working through this language. We heard this bill in committee. We had some concerns about when attorney's fees would be awarded, and I really appreciate this amendment by striking lines 9 through 21. So I urge an aye vote. Thank you.
Thank you. So is there any further discussion on L003? Seeing none, the question before us is the adoption of L003 to the committee report for State Civic, Military, and Veterans Affairs, HB 23-1259. All in favor, please say aye. Aye. All opposed, no. Okay, the ayes definitely have it. The L003 is adopted. Representative Evans, do you have more on the committee report?
Nope, to the bill.
Okay, well, we need to adopt the committee report. So the question before us is the adoption of the State Civic, Military, and Veterans Affairs Committee report to HB 23-1259. All in favor, please say aye. Aye. All opposed, no. Okay, the ayes definitely have it. HB 23-1259 committee report from State Civic, Military, and Veterans Affairs is adopted. Now to the bill. Representative Evans.
Thank you. Sorry, I have 3 bills up here in a row. So to the bill. Again, as I've mentioned before, the point of this bill is trying to do that good work of legislating by trying to balance 2 very important competing interests. On the one hand, we want to ensure that we're always preserving and protecting the transparency and the right of citizens to be aware of what's going on in their local bodies. But we also want to ensure that those local bodies are not being unduly burdened by a whole lot of lawsuits over like mere technical and administrative violations. So one particular area in which we've seen a lot of lawsuits here in Colorado revolves around executive sessions. So what executive session is it's a very clearly delineated process in law. I think there's 8 particular reasons why a local body might go into executive session. These are things that are talked about in advance. They have to be promulgated to the community in advance. There's a whole lot of information that goes into ensuring that the community has as much information as possible about why that local body is convening an executive session. The issue arises, coming from a lot of our smaller rural municipalities and school districts, insofar as they may not even be large enough to have an attorney that is able to help them in writing and publishing and promulgating those executive session notices. And so what that does is that creates a situation where that local body thought they did the right thing. They thought that they put out all of the information to which the community was entitled for the executive session, but they might have made a small typo or administrative error. As an example, they might have cited the wrong subsection in a law. They might have said, hey, we're convening this pursuant to, CRS title, whatever, sub A, and they really meant sub B. So under current law, somebody could actually bring a lawsuit against that municipality and say, hey, you did not properly go into executive session, therefore it was an illegal executive session, and therefore we are suing. Typically the amount is for a small enough amount to where the local body decides, hey, it's more worth it to settle out of court, just pay the $3,000, $4,000, $5,000, whatever it is. It's more worthwhile to settle out of court, just pay the fee, than it is to fight this through litigation and point out that, hey, this is actually, perhaps just an administrative error. And that's very impactful for a lot of these small rural communities. We heard testimony in committee that talked about for some of these local bodies, like $3,700 might be their entire field trip budget for the year. And so what we want to do is we want to make sure that we're protecting and preserving that transparency while also ensuring that local bodies have the right to cure any technical violations if they went into executive session. And so what this bill does is it really just lays out a process that says if a local body goes into an executive session and there's an administrative error by which they went into executive session, if somebody has issue with that, what they need to do first is notice that public body and see if this is something that can be administratively cured. If it's something that can be administratively cured, then the local body can cure that at their next meeting, and then everybody can go along. It saves taxpayer monies because that body's not having to pay out fees, and it also ensures that citizens still have the transparency to which they're entitled. On page 3 of the bill, it's important to notice that we've clearly excluded any sort of potential illegal activities from this. It states an executive session that is entered into for a purpose not authorized by law cannot be cured. So if you're doing something wrong, this bill doesn't apply. This is solely to cure those administrative violations. Now, in some discussions that we had in committee, there were some concerns that were raised, and so to address those concerns, I move Amendment L004 to the bill and ask that it be displayed.
Thank you. L004 has been properly moved and displayed. Please proceed. Tell us about your amendment.
Thank you, Madam Chair. So what L004 does is it clarifies that a pro se plaintiff, so what you have there, that's basically an attorney or somebody that's representing themselves. They're not representing a client. Somebody that's representing themselves, they still have standing to sue a local public body if they feel like that cure that the local body had was not an appropriate cure. But what this amendment specifies is that if you're a pro se plaintiff, you're representing yourself, and not necessarily a client, it basically says that you are not entitled to paying or receiving any fees. So what we're trying to do here is we're just trying to make sure that this is not fostering a lucrative situation in which an attorney can go around the state, find technical violations in a local body, sue them, and then go collect a few $1,000s from each lawsuit filed if they are a pro se plaintiff. This is actually a situation that has been occurring in parts of the state, and so I would ask for your aye vote on Amendment L004.
Thank you. Is there any further conversation on L004? Representative Woodrow.
Thank you, Madam Chair. Again, colleagues, this addresses a concern that we heard in committee, and I would urge an aye vote.
Thank you. Is there any further discussion on L004 to HB 23-1259? Seeing none, the question before us is the adoption of L004. All in favor, please say aye. Aye. All opposed, no. Okay, L004 is adopted. To the bill, Representative Ortiz.
Thank you, Madam Chair. I'm going to go ahead and move L002 and ask that it be displayed. They've got it.
Okay, thank you very much. L002 has been properly moved and is displayed. Please proceed.
Awesome. And we heard this bill in committee. Really appreciate the bill sponsors working with everybody to make sure we get this bill to a better place. The bottom line of what this amendment does is trying to crack down on repeat offenders. So if a body is committing the same violation over and over again, on the third time within a year, if they're committing the same violation, it can be taken to court. So that's all this amendment does.
Thank you. Is there further discussion on L002? Representative Evans.
Thank you, Madam Chair. So I appreciate Rep. Ortiz bringing forth this. It's something we completely agree with. If you're screwing this up 3 times in 1 year, you probably need to take a longer, harder look at what you're doing wrong. Completely support this amendment. I would ask for an aye vote.
Thank you. Representative Bottoms. And you're speaking to the amendment, not the bill, correct?
Thank you, Madam Chair, and thank you first for the bill sponsor for making these changes, and also for the representative that just submitted this amendment. This is a good amendment. This is part of what we discussed in committee, and this makes the bill much better. I was really struggling with the bill in committee. I talked about this. This is one of my concerns, and I know it was Representative Ortiz's concern. So this is a good amendment, and this gets the bill really, really, really close to a yes vote for me.
Thank you. I'm sure everyone is excited to hear that. So is there any further discussion on L002? Seeing none, the question before us is the adoption of L002 to HB 23-1259. All in favor, please say aye. All opposed, no. Okay, L002 is adopted. To the bill, is there any further discussion on HB 23-1259? Representative Wilson.
Thank you, thank you, Madam Chair. I rise in support of this bill, and I just want to briefly discuss how important executive sessions are. When you are on the local level, you have to make decisions about purchasing of property, and you don't want the person selling the property to know how much you're willing to spend. Things like that, when it comes to protecting staff, if there's an issue with staff, you want to give that staff member the opportunity to decide whether or not the discussion about that staff member takes place in public or private, and that's the staff member's option. These things are really important for the benefit of the town. Same with discussions with your attorney. You don't want your defense to know what your lawyer's strategy is. So it's important to have these, this ability for local governments to have executive sessions. And open meeting law is already very specific, so it is required that you do things a specific way. This bill tightens that up and keeps everybody in line while still giving you the ability to move forward and conduct the business that you need to conduct in private. So I ask for a yes vote on this bill. Thank you.
Thank you. Representative Puglisi.
Thank you, Madam Chair. I rise in support of this bill as well. Really appreciate the representative from Weld County consulting with me as a county attorney in a small rural county about his bill, and I appreciate the amendments as well. It can be incredibly difficult. We try so hard as county attorneys to make sure we don't miss anything. All attorneys do. But if we made an administrative mistake, having the ability to cure that without compromising the executive session is also really important. I give legal advice. We have personnel matters, sale and purchase of real estate. All of those things need to happen in close quarters. We do have statute that allows that. And there are definitely some repeat people who enjoy suing counties, local governments, and for some of these small rural counties, they don't have capacity. So I'm a county attorney, I'm a department of one, and so when you have a litigation matter, it takes up a long time, and I don't personally do litigation. It's very stressful on the county and county resources, and so having that ability is really important. So really appreciate the bill sponsor for bringing this forward. It's a great bill, and would urge an aye vote. Thank you.
Thank you. Representative Winter.
Thank you, Madam Chair.
I also stand in support of this bill. I don't know how many times I've got up here in the last 2 months and talked about how unfunded mandates and things that we do in here really affect rural and frontier counties. And the good representative from El Paso County is correct. A lot of times our county attorneys are an office of one person, and meetings are fast and furious, and sometimes things just get lost in the wash. And this gives them the ability to step back, correct these things. Sometimes things are nefarious, but a lot of times these mistakes happen, and they deserve a chance to be corrected without getting the book thrown at them. So thank you for bringing the amendments to this bill. Thank the bill sponsor from Wild County for bringing this bill. My rural frontier counties appreciate you and knowing what it takes to get things done. So I urge a yes vote on this. Thank you.
Thank you. Representative Frizzell.
Thank you, Madam Chair. I talk a lot about my local government experience, and I rise in support of this bill. I am the first person to tell you that transparency in government at any level is critical. It's critical to citizen trust that their government is working on their behalf with the best intentions. It is critical for those elected officials to know that they're going to be held accountable. At the same time, things happen in government, whether it is an employee issue that needs to be dealt with privately or working out difficulties among elected officials. It's not always great to air your dirty laundry in public. There are many, many reasons, legal reasons, that it's important to have executive sessions. And I rise in support of this bill because that needs to be maintained. At the same time, as soon as you get done with your executive session, come out and let everybody know what you discussed and what the outcome is, because that's important. Thank you very much to the bill sponsors. I appreciate you bringing this forward.
Thank you. I'm Representative Parenti.
Thank you, Madam Chair. I just have some questions, some clarifying questions for the bill sponsor. The curing process that's proposed here, would it allow for the curing of an executive session that was failed to be disclosed?
Representative Evans, do you care to comment?
Thank you, Madam Chair. No, it would not. So that was that part of the bill that I read, if I can find it in all my papers here, where it talks about an executive session that's entered into for a purpose not authorized by subsection 4. So those are all of the things that they have to go through in order to enter into that executive session. So if they're not making the notices, if they're not disclosing that to the community as appropriate, then no, this would not be something that could be cured because it was in violation of how they were supposed to enter into it. It wasn't just a technical violation.
Thank you. Is there further discussion? Representative Parenti.
Yes, so a couple more questions, or at least one more. So is there more guidance that can be provided on what qualifies as a technical violation versus, and let's face it, we do have some forms of local government that use executive session to hide what they're doing. And this is not, we don't want to give them the opportunity to just 2 weeks later say, oh, sorry, this is what we said, this is what we meant we were going to do at the last executive session.
Thank you, Representative Evans.
Yeah.
Thank you, Madam Chair. Yeah, so that's part of the House committee report here, where we wanted to just clarify a little bit more. What does it mean to cure this? And so on the committee report, it talks about determining if the person's challenge, so that's the challenge to the executive session, if it can be resolved, that is cured, means that they basically have to sit down and work together to see if there's a solution to the deficiency of the prior announcement of the executive session that is alleged to be in violation, to address the person's challenge and then basically bring that local government back into compliance with subsection 4, where it talks about all of the things that you have to do in order to properly go into executive session. So really what it does is says you got to sit down and talk about it. Now, if you can't come to an agreement there, we totally understand that you can't come to an agreement there, in which case the current process that we have in place now still applies. You can still take that local body to court, just as you can now, and still challenge that they didn't do something appropriately. So we're not taking any of that away. The only guardrail that we're putting around that is that you basically can't do it for profit. So yes, that amendment that we brought in committee provides the guidance by which a person has to sit down and see if they can hash this out beforehand. If they can't, they are still entitled to all of the remedies of law that they have today, with the exception that they can't do it for profit if they're a pro se plaintiff.
Thank you. Is there further discussion on HB 23-1259? Seeing none, the question before us is the adoption of HB 23-1259 as amended. All in favor, please say aye. All opposed, no. HB 23-1259 is adopted as amended. Okay, Mr. Schiebel, that brings us back to HB 23-1102. Can you please read the title of HB 23-1102?
House Bill 1102 by Representatives Evans and Byrd, also Senators Roberts and Hansen, concerning the high visibility alcohol and drug impaired driving enforcement program.
Thank you, Representative Byrd.
I move House Bill 1102 and the Appropriations Committee report and the Judiciary Committee report.
Okay, thank you. To the Appropriations report, Representative Byrd.
In the Appropriations Committee, we made clear that the appropriation that's being made goes to the Office of Transportation Safety. And also, we changed the funding source that was originally identified in our bill from the Marijuana Tax Cash Fund to instead have an appropriation coming from the State Highway Fund.
Thank you. Is there any further discussion on the Appropriations Committee report? Seeing none, the question before us is the adoption of the Appropriations Committee report to HB 23-1102. All in favor, please say aye.
Aye.
All opposed, no. Committee report, Appropriations Committee report to HB 23-1102 passes. Okay, that brings us to the Judiciary report. Representative Byrd.
Thank you, Madam Chair. So, members, in the Judiciary Committee, we amended our bill to require law enforcement agencies that are receiving grants under the High Visibility Enforcement Program to submit to the Office of Transportation Safety a copy of their written policies and procedures that explain how these different agencies perform training to ensure that their officers don't engage in profiling. Also, these participating law enforcement agencies must certify to the Office of Transportation Safety that the agencies comply with reporting requirements that require detailing of such things as use of force, demographic data relating to people who are contacted by law enforcement officers, anytime use of force happens, what type it was, whether officers were on duty in these involved situations. There's a whole host of reporting that's there. And also, we amended the bill to ensure that in this program, no city or local government would be eligible for this grant program if they are subject to a judicially ordered consent decree. So we ask for a yes vote.
Thank you. Is there any further discussion on the Judiciary Committee report? Seeing none, the question before us is the adoption of the Judiciary report to HB 23-1102. All in favor, please say aye.
Aye.
All opposed, no. Okay, the ayes definitely have it. The Judiciary report to HB 23-1102 is adopted. To the bill, Representative Byrd.
I move Amendment L012 and ask that it be displayed. And did I move the bill? We already moved the bill.
Yes, you did.
What?
The committee will stand in a brief recess. The committee will come back to order. Representative Byrd.
So, members, we passed our committee report too fast. I have 3 amendments that were supposed to be made to the committee report. So what we're going to do is fix this all tomorrow. But a part of the process of fixing this tomorrow is Rep. Evans and I will be asking you for your yes vote on this bill. And then when we rise and report and we have committee of the whole, we are going to offer a cow amendment to say that this bill actually did not pass. And that will give Representative Evans and I the opportunity to bring this back and make our amendments to the committee report and do this the right way tomorrow. And I hope that makes sense. And with that, I ask for a yes vote on this bill.
Representative Evans.
Thank you, Madam Chair. What she said, we ask for your yes vote.
Okay, word to the wise. Always understand what your committee report is amending before or what your amendments are amending. But to that end, any further discussion on HB 23-1102? Seeing none, the question before us is the passage of HB 23-1102. All in favor, please say aye. All opposed, no. Okay, HB 23-1102 passes, oddly. Okay, Madam Majority Leader.
Thank you, Madam Chair. I move the committee rise and report.
Seeing no objection, the committee will rise and report.
The House will come back to order. Mr. Schiebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report it as under consideration the following attached bills, being the second reading thereof and making the following recommendations thereon. House Bill 1102 is amended, 1155 is amended, 1182 is amended, 1250, 1259 is amended, 1261 is amended, 1262, 1263 is amended, 1268 is amended, 1275 is amended, 1276, 1280 passed on second reading in order engrossed and placed on the calendar for third reading and final passage. House Bill 1161, 1162, 1245, and Senate Bill 60 laid over until April 14th, 2023.
Representative Kipp. Members, you have heard the motion. There is an amendment at the desk. Mr. Schiebel, please read the Byrd amendment to the Committee of the Whole report.
Representative Byrd moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in adopting the Appropriations Committee report to House Bill 1102 dated April 10, 2023 and the Judiciary Committee report to House Bill 1102 dated February 15, 2023 to show that said reports did not pass and that House Bill 1102 was laid over until April 14, 2023.
Representative Byrd.
Members, it is with a contrite heart that I ask you to vote yes for this cow amendment and allow Representative Evans and I to return tomorrow and talk to you about our bill.
Please move the
And
Byrd.
I move the Byrd amendment to the report of the Committee of the Whole.
And
I ask that it be properly displayed. I'm rusty at this.
No worries. One moment. It is properly displayed. Seeing no further discussion, the question before us is the adoption of the Byrd amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Please close the machine. With 58 aye, 5 no, and 2 excused, the Byrd Amendment is adopted. There are no more amendments at the desk. The question before us is the adoption of the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Froelich, how do you vote?
Yes.
Representative Froelich votes yes. Representative Vigil, how do you vote?
Yes.
Representative Vigil votes yes. Representative Epps, how do you vote?
Yes.
Representative Epps votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Please close the machine. 44 aye, 19 no, and 2 excused. The report of the Committee of the Whole is adopted. Announcements? Seeing none, Madam Majority Leader. Oh. Representative Catlin.
Thank you, Madam Chair. It's an honor to serve with you tonight.
Honor to serve with you.
Thank you. I wanted to announce that I've been graciously granted Tuesday and Wednesday next week off so that I can go talk about the Colorado River. Thank you.
Nothing more important. Thank you, Representative Catlin. Representative Sirota.
Thank you, Madam Speaker. House Appropriations will meet tomorrow morning in the Old State Library at 8 a.m. to hear all of the bills in the calendar except House Bill 1198 and House Bill 1223.
Yeah. Madam Majority Leader.
Madam Speaker, I move to lay over the balance of the calendar until Friday, April 14th.
Seeing no objection, the balance of the calendar will be laid over until Friday, April 14th. Madam Majority Leader.
Madam Speaker, I move the House stand in recess until later today.
The House will stand in recess until later today. Members, you are free to go. We just have additional business we need to do tonight. Thank you.